Good morning. We need to address anything before we get started? All right, good. I like to hear that. And Mr. Proctor's here?
He's outside.
Okay, good. Hey.
Ready for the jurors?
Yeah.
Jurors in the courtroom, Your Honor.
Okay.
Jurors may be seated. All jurors are serving the court, Your Honor.
Thank you, Deputy. Good morning, ladies and gentlemen. Were you all able to abide by my instructions during the recess? Excellent, thanks. Well, we'll get started. State? You gonna call Mr. Proctor back?
May I have a moment, Judge?
Sure.
Your Honor, State will call out on Proctor.
All right, thank you.
Your Honor, may I?
Oh, yeah, and I'll remind him that he's still under oath. Yeah. You go ahead. Mm-hmm. He has. Morning. I'll remind you that you're still under oath. Oh, sorry. Thanks, Terry. Go ahead, Mr. Escobar.
Thank you, Your Honor. Good morning, Mr. Proctor.
Good morning, sir.
Mr. Proctor, you remember we left off with your last statement where you told this jury that you had probable cause based on a totality of circumstances to arrest Mr. Reeves. Remember that?
Yes, sir. Something to that effect. Yes, sir.
Okay. And so you would agree with me that that process requires the application of facts that you have learned in the investigation
Yes, sir.
from witnesses and from the evidence,
That's correct.
and applying the law in this case.
Yes, sir.
And so what is the law on justifiable use of deadly force, Mr. Proctor?
Judge, I'm going to object. Mr. President.
Yes.
Now, Detective, from the very beginning, you weren't supposed to be assigned to this case, correct?
That's correct.
In fact, it was Detective Soto that was supposed to initially be assigned to this case,
Yes, sir.
and he was on the other end of the county,
That's correct.
and because of the time that it was going to take in order for Detective Soto to come, you were assigned to this case, correct?
That is correct, sir.
And you would agree, would you not, Detective, that you were only assigned as a homicide detective in one prior case dealing with self-defense,
That's correct, sir.
prior to the Mr. Reeves's investigation?
Yes, sir.
Is that correct?
Yes, sir.
And you would agree as well that you had never taken a course dealing with the issue of self-defense and homicide?
Not a formal course, no, sir.
And you were really only somewhat familiar with the law of self-defense?
Yes, sir, that would be correct.
Now, Detective Aaron Smith was going to be the crime scene detective, is that correct?
That's correct, sir.
Okay. And the crime scene detective is in charge of the crime scene.
That's correct.
That's a very important function, is it not?
Yes, sir.
And the reason that it's an important function is because in our system of justice, when you're out there, you're supposed to preserve all of the evidence, correct?
That is correct.
You're supposed to preserve the evidence for the prosecution, correct?
Yes, sir.
You're supposed to preserve the evidence for the defense,
That is correct.
and you're supposed to preserve the evidence for the community.
Yes, sir.
Because when an incident like this is investigated, you don't call the public defender's office and say, hey, come on over and join us so that we can likewise investigate the case, right?
That's correct, sir.
Okay. And you certainly don't call a private attorney like me, right?
No, sir.
Okay. Now, Detective Aaron Smith was quite new in the homicide section of major crimes, correct?
That is correct, sir.
In fact, maybe weeks or days before, he was a detective investigating missing persons.
I believe he had been in that unit a month, 2 months in the unit.
Okay. But before that, he was investigating missing persons.
Yes, sir, which is was under the umbrella of major crime.
Okay. And so when he came into that particular unit, he was going to be shadowing you.
He had shadowed me, yes, sir.
Is that correct?
That's correct.
So if it was a month, he was shadowing you for a month.
Yes, sir.
And you knew, did you not, that Detective Smith had not even been to the homicide investigative course by that time?
I'm not aware if he had been or not, sir.
Now, when you first got there, and I'm going to give you a pad to make it easy. May I approach your honor? Okay.
That's fine, sir. I have my own pen.
You've got your pen? Okay. Just because if you need to jot down some notes, that'd be good. What time did you get there to the Cobb Theater?
According to my notes, sir, I arrived on scene at 2:15.
At 2:15, and what is that in military time?
14:15.
14:15. Okay, why don't you jot that down if we can?
Yes, sir.
Okay, and so you get there to the Cobb Theater scene. You don't know yet whether you're going to be assigned the case or not, correct?
That's correct.
And so you're kind of waiting around.
I see every single one is wasting.
I'm very sorry. Someone sent me a video. I'm very sorry.
You were waiting around.
Waiting around.
Yeah, you got there, you didn't know if you were going to be assigned yet. It took some time for that decision to be made.
Not really, sir. I met Acting Sergeant Harris and Major Corbin. As I was getting out of my vehicle, I saw them standing there. I pulled up next to them. We got out and we were talking. about the incident.
Okay, and were you talking about the fact that Soto was on the other end of the county?
That's what I believe Sergeant Harris told me.
Okay, and so at some point in time in that conversation, a decision was made to assign you to this case?
That's correct.
Okay, and so, do you know what time that was?
I do my first interview with Alan Hamilton at 14:27.
Okay, so let's jot that down. 14:27 is your first contact with Alan Hamilton, correct?
That's correct.
Okay, and so you didn't do anything between the time you arrived and your first contact with Alan Hamilton, other than speaking to the sergeant?
I received a briefing from them as to what had occurred,
The sergeant?
and Major Corbin.
Okay, and so by this time you realized it, and where were you when that conversation took place?
With Harris and Corbin
Yes, sir.
in the parking lot.
You were in the parking lot. Is that where a command center had been set up?
Not at that time, sir, no.
Okay, well, did a command center get set up?
I don't remember, sir, that. I don't remember. I think they might have had a mobile command center there as I was leaving. I'm not for sure.
As you were leaving for the day?
Yes, sir. I was in and out, and that's one of the things I was not paying attention to.
Okay. So, certainly, you knew that there was a large force of police officers, correct?
Yes, sir.
And you knew the minute that you were assigned this case, that it was now your responsibility to make sure that this case was investigated
Yes, sir.
properly.
Yes, sir.
And you had the awesome responsibility of making sure that the evidence was going to be preserved, that witnesses were going to be adequately interviewed, correct?
Yes, sir.
And that those interviews were going to be properly memorialized.
Yes, sir.
Okay, and so, let me ask you a question. Before going to your first interview, which was a mere, 12 seconds after you arrived? Excuse me, 12 minutes after you arrived? You arrived at 14:15, Alan Hamilton, 14:27. I'm not great in math, that's why I became a lawyer.
12 minutes, yes, sir.
12 minutes, okay. And so, within 12 minutes from you arriving, you are now going to be interviewing Alan Hamilton, and that took place where?
In the theater, I believe it was in the party room.
Okay, so you had to have some time, since you were talking in the parking lot with the sergeant, there was some walking time to get over to that theater, correct?
Just a couple of minutes, yes, sir.
And then get in there and sit down.
Yes, sir.
Okay. Now, in order to do that, you had to walk through the lobby.
That's correct.
And you, as you walked through the lobby, you could see a bunch of people, patrons, lay people, congregating, correct?
The lobby was, they had a lot of people in the lobby.
And those people were not police officers, these were lay people, patrons of the theater.
There was some law enforcement in that group.
Okay, but the majority was lay people, right? Witnesses.
There were a lot of people, sir. There again, I didn't get a count on them or anything, but there were a lot of people in that lobby.
In those 12 minutes, did you go to the officers that were there in the lobby and tell them, hey, officers, this can't be. We got to separate these witnesses? Did you tell them that?
I know, sir.
Did you tell those officers, hey, officers, please, you need to tell these individuals not to talk to each other?
No, sir, I didn't tell them that.
You are quite familiar, are you not, with the issue of contamination, correct? Witness contamination.
Yes, sir, I am.
In fact, that was taught to you as early as your time in the academy, when you first became a police officer, right?
Yes, sir.
And what they taught you was clearly that you've got to separate witnesses. Because if you don't, the information that's exchanged contaminates, right?
Yes, sir.
And not only does it contaminate, it may be wrong, correct?
That's correct.
And not only can it be wrong, but the person that's hearing it actually believes themselves that they own it now. Correct?
That could be, yes, sir.
In fact, they start believing it and actually think that they're seeing it.
Objection, speculation.
Sustain.
So, in order to get to Theater 11, is that where you were?
No, sir.
What theater did you interview Mr. Hamilton?
In the party room.
Party room, and where's that at?
It's right inside the entrance
To the right or left?
to the right.
To the right. Okay, so in order to get into that party room, you can see Theater 10, right? You can see the Theater 10 sign?
Yes, sir.
Okay. And you knew at the time that you were assigned this case that the incident had occurred in Theater 10.
That's correct.
And you passed Theater 10 and you didn't go into Theater 10.
No, sir.
Well, you knew that there were officers in Theater 10, correct?
Yes, sir.
You weren't going to do anything to contaminate the scene if you had gone into Theater 10, right?
That's correct, sir.
You knew the incident had occurred there, right?
Yes, sir.
You didn't know what evidence existed or didn't exist in Theater 10.
At that particular time, no, sir, I did not. I knew there was a popcorn and a cell phone.
Oh, so before you went into the party room, you're telling me, in this jury, that you knew that there was popcorn and a cell phone where?
On the aisle.
On the aisle. Did you know the measurements of that aisle?
No, sir, I do not.
Did you know the measurements of the seat?
No, sir.
Did you know the measurements from seat 9 to the seat right in front of row 9?
No, sir.
Did you know at that point in time what the lighting conditions were at the time the previews were playing?
Other than it was being dark, no, sir.
Did you know what previews were playing and how loud they were?
No, sir, I did not.
Now, previous to this particular incident, it had been at least a year before you had been to the theater itself, and I'm talking about the complex, correct?
That's correct, sir.
And in fact, you don't even remember, as you were there, you don't even remember that you had ever been in Theater 10.
Sir, I remember going into one of the theaters. I don't remember which theater number it was, but I remember being at that complex, and I thought it to be Theater 10 with the bistro.
You remember, page 52, Debo, lines 16 through 18. Do you remember,
Judge, I'd ask for the date.
my apologies, Judge. I should have said the date. March 27th, 2015. You would agree, you remember the depot that you and I had on that date, correct?
I remember giving you a depot, yes, sir.
Okay, and you remember being placed under oath?
I do.
And you remember me asking you a series of questions
Yes, sir.
about this incident?
Yes, sir.
And you would think certainly that your mind was clear, or certainly you had a better recollection of the events back in 2015 rather than 2022.
Yes, sir.
You remember the following questions. Have you ever been in Theater 10? Answer. I've been to the Cobb Theater. I don't remember what theater I've been in. Were you telling the truth back in 2015 when I asked you that question?
I've never read that depot, even though at the end of the deposition I asked to read before it was published. And I've never had the opportunity to read that deposition.
Did you call the court reporter as you were supposed to?
Judge, object. Can we approach?
Yes.
Now, so you go into this party room, correct?
That's correct.
And Detective Smith, was he there already?
I believe so, yes, sir.
Okay, and so he was going to go into the crime scene.
That's correct.
However, you don't know, at least you didn't know in 2013, whether Detective Smith had ever been assigned as the lead crime scene detective in a homicide.
That's correct, sir.
So I'm sure that caused you to at least think, I've got to be careful. Because if he's never been assigned as the lead detective to a crime scene, he may need some guidance, right?
Sergeant Harris was there.
Well,
No.
did you tell Sergeant Harris, please make sure that you go and speak to Detective Smith to make sure that he's got a real handle on this?
This crime scene was relatively, it was an in-depth crime scene, for lack of a better purpose,
How did you know? You weren't in there.
because I had been told that of the evidence inside. There was popcorn on the floor, there was a cell phone, a spent casing, those kinds of things, but it was not an in-depth crime scene. I had complete confidence in Detective Smith. I had complete confidence in my team to process the scene correctly. They had been trained in that. They knew their job, and I had complete confidence in them. I did not go into the theater to see those items on the floor before I did my interviews.
Okay. So now, before going in to do this interview with Corporal Hamilton, is that correct?
Yes, sir.
Okay. Corporal at the time.
Yes, sir.
You knew nothing about Curtis Reeves, correct?
I knew that he was an ex-Tampa police officer,
That's it.
that he was an older gentleman, and that he had been detained for shooting Mr. Oulson.
You certainly didn't know about any extensive training that he may have had as an officer with the Tampa Police Department.
No, sir.
And you certainly didn't know that at one point in time he was the commander, actually, he started the SWAT team at TPD, right?
No, sir, he told me that, well, he didn't tell me about starting the SWAT team in the, with Tampa, but he told me that during his interview.
Well, no, that's further down. We're talking right now, right before you go into that little room to interview Corporal Hamilton. You didn't know anything concerning his extensive training that he had.
There again, sir, he had just shot a man. It didn't matter if he was law enforcement, if it didn't matter who he was. He had just shot somebody. And at that time, that did not weigh on me as far as needing that information. I wanted to gather everything that I could to present to the court. And at that time, I did not feel I didn't feel the need to go into his background.
Okay, well, we're going to get into that in just a little while. And so now you go into this room with Corporal Hamilton, is that correct?
That's correct.
Okay, and what you told the jury during direct examination is that you go into this room and Corporal Hamilton was supposed to be an eyewitness, right?
That's correct.
Okay, and you knew he was a police officer, right?
That's correct.
Okay. And so you go into this particular room with Corporal Hamilton, and you decide that you're going to talk to him about this incident, but you're not going to turn on your tape.
At the start of the interview, that's correct, sir.
Well, it was about, what, you spoke to him about 5 minutes off tape?
Yes, sir.
Okay. And so for 5 minutes, you're talking to him about this particular incident, and you told the ladies and gentlemen of the jury yesterday that you did that because you wanted to know what he was going to say.
I wanted to know if he was going to be able to communicate it to me in such a way that I would be able to understand it.
Well, who cares? You turn the tape on, you let him communicate whatever he wants to communicate, and now we
Judge, I
know...
object, he's being argumentative with the witness.
I'm not being argumentative.
Overruled.
Detective, you turn on the tape recorder.
Yes,
You get it from the very beginning. If he's not making sense, then we know that maybe he's excited about what happened or he's concerned about what happened, but we get all of his words, right? There's nothing wrong with that.
Yes, sir.
You would agree with that. You want to get sometimes, many times, the emotions of the individual, correct?
At times, yes, sir.
And the uncertainties of individuals, correct?
Yes, sir.
Or sometimes the precise information from the individual, correct?
Precise information, yes, sir.
And so that's all captured by a recording.
Yes, sir.
And if you don't record all that, it goes out the window. Right?
Yes, sir.
And your responsibility in this case was not only to the prosecution, but your responsibility in this case was to preserve everything for this community and for the defense.
That's correct.
And you chose not to do that. Now, what you did was you got some kind of checklist. I believe you told the jury yesterday that you just, jotted down what he said, and then you were just going to go down that list, right? That's what you did.
It's not a checklist. I was taking notes as to what he told me.
And then you, in that interview that's recorded, you just go down and ask those questions that he already answered.
That's correct.
But you don't know how he answered them, what his emotions were, what his recollection really was, nothing.
The tape stands for itself, sir.
Well, that's the tape after the first 5 minutes.
Yes, sir.
Now, let me ask you this question. Did you have in front of you, before you started that interview, did you have a voluntary statement form that he had filled out, signed, and dated? I believe it's on page 2 of your report.
Yes, sir, I do.
And you had it in that room, correct?
Yes, sir, I believe I did.
And so you were aware, you read it, right?
I did.
Okay, and so you were aware that Mr. Hamilton had indicated that Mr. Oulson was coming over the back of his seat yelling at Mr. Reeves.
If I could review the written
Oh,
statement.
absolutely. Your Honor, may I approach? I'm going to hand you what's been marked as Defense Exhibit number 21.
So your question, could you reword or do the question for me again, sir?
Absolutely. So you were aware when you read that statement, right? Let me have it back, and I want to do it verbatim so that we don't have any mistakes. You were aware that I observed a white male stand up to my right, lean over the back of his seat, and begin to yell something to the effect,
Yes.
voluntary statement that you had,
Yes, sir.
what were you aware of at that point from Mr. Hamilton?
That he had witnessed the shooting.
Well, and what had he witnessed? I'll put that in front of you so you can refresh your recollection if you need to.
Judge Ott?
We're going to object. This is hearsay. Mr. Hamilton already testified. Just going through the previous testimony with the different witnesses inappropriate.
He can refresh his memory with it, but
Yeah. So what, you can look down if you like.
Yes, sir.
Okay. And so what did you know?
That he was at the Cobb Theater, that the movie had began. He observed a white male.
Your Honor, I think we're...
yeah. All right. I'm going to overrule.
Go ahead.
He stood up, the white male stood up, and according to this statement, he leaned over the back of the seat and began to yell something. "I'm trying to text my fucking daughter, if you don't mind."
Okay.
And then he observed him throw
Your Honor, I
a,
think...
Okay, okay.
Okay. But I can have it read more if you want.
No,
Okay.
that was
Okay.
what we talked about.
Okay. Okay, so you had that before you even started questioning Corporal Hamilton, correct?
yes, sir, I believe so.
And you would agree with me, may I approach you all?
You may.
You would agree with me that Defense Exhibit number 21, take a look at it, is written very neatly. Correct?
Yes, sir.
Okay. And so, I think that on direct examination yesterday, you acknowledged that, hey, we really should be turning these recorders on from the very beginning, right?
Yes, sir. It did not, however, change his statement.
Okay. Now, you interviewed Corporal Hamilton with his wife present.
No, sir, I did not.
So his wife was not present when you interviewed Corporal Hamilton.
That is correct.
You're telling this jury then that the only time that Corporal Hamilton and his wife were present is when you were interviewing her.
That's correct.
Okay. Now, your interview of Corporal Hamilton was 5 minutes off tape, correct?
About that, yes, sir.
And 6 minutes on tape.
About that, yes, sir.
Okay, so let's put down now, we've got the time that you came in, 14:50, the time that you started Hamilton's interview, 14:27,
Yes, sir.
and the time that you ended that interview, which was
2:38, 14:38.
14:38. Okay, 2:38.
Yes, sir.
Now, after that particular interview, you go to interview the wife, is that correct, Mrs. Hamilton?
Yes, sir.
Okay, and did you interview her in that same room?
I did.
And you still had not bothered to go back into the crime scene to, or not even back, you hadn't gone, period, to the crime scene to go see anything in there?
That's correct.
Okay. And when you interviewed her, you likewise started that interview without turning the tape on.
Yes, sir.
And your reason for doing that was because of what?
I wanted to make sure that she could communicate in such a way that I could understand it.
Well, you would agree again with me that if you had that tape on from the very beginning, we would know possibly her emotional state.
Yes, sir.
We would know whether she was sure or not
Yes,
of
sir.
what she was telling you,
Yes, sir.
whether she was undecided about certain events,
Yes, sir.
and we weren't able to capture that because it wasn't recorded.
That's correct, sir.
Okay, and so after that initial interview, how long was that initial non-recorded interview?
Uh, 2:43 is when I started.
And you left the other one at 14:38, so at best 5 minutes if my math calculations are correct?
Yes, sir.
Okay. So 5 minutes possibly off tape and on tape.
I've got to hear that it was, the taped interview was from 14:52 to 14:57.
14:52.
Yeah, 2:52 to 2:57.
Okay. So now, you get her statement in the same manner that you got, the recorded statement, in the same manner that you got Mr. Hamilton's, is that correct?
Yes, sir.
Okay, you had jotted down your notes, and then you go through those notes, correct?
That's correct.
Okay. Now, clearly, in this particular interview, you had Corporal Hamilton there, listening to what his wife was saying.
Yes, sir.
And you agree with me, that violates protocol at the Pasco Sheriff's Office, right?
Yes, sir, possibly.
Okay. Now, when you went to go get Ms. Hamilton in order to do this interview, where was she?
Out in the lobby, I believe.
And was she out in the lobby with a group of patrons that had gone to the theater to view the theater?
I'm sorry, sir?
Yeah, out in the lobby,
Right.
concession area. Was she in that group of individuals that had been in the theater during the time of this incident?
There again, sir, she was out in the lobby. I don't recall where she was at. She was near that party room. I remember there being windows, I believe, around that party room. And I sat looking out the window, and I did my interviews with them facing the wall, is how I recall it, sir.
My question is in the lobby area. She was in the lobby area with those people.
Yes, sir.
And that's where you all went to retrieve her.
That's right. That's correct.
And you certainly, when you went to retrieve her, you didn't hear any police officers warning those individuals not to talk to each other.
No, sir.
And you certainly didn't give any instructions to officers to do just that.
That's correct, sir.
Okay. Now, since you took notes of both Corporal Hamilton and Mrs. Hamilton, you took notes there in that party room, correct?
Yes, sir, I did.
You don't have those notes because you shredded them.
That's correct.
It wouldn't have been difficult for you to just attach them as a piece of evidence, right?
That's not procedure protocol. These are my notes.
So you want to follow procedure protocol concerning the destruction of the notes, but you don't care about following procedure protocol when you're interviewing individuals together.
Sir, it's been a few years since I've read that procedure, but the thing that you do not want to do is interview two witnesses together without having at least one of those individuals interviewed. In this particular case, like I explained yesterday to the court, I had interviewed Mr. Hamilton. I had obtained the information that I felt I needed at that time. I had saw his wife. She was upset. I wanted to get the very best statement that I could from her. Mr. Hamilton knew not to say anything during the interview. He simply sat behind her with me facing her and him behind his wife at a different table.
Did you put all that in your notes, Detective, that you shredded?
No, sir.
Okay. So now you're done with both interviews.
That's correct.
And the one thing that you knew, that there was yelling and curse words that were being directed from Mr. Oulson to Mr. Reeves, correct?
Yes.
Leaning over the back of the chair.
That's correct, yes, sir.
And so you would agree that that is an indication to you that Mr. Oulson was aggressive.
Objection, Judge. Can you approach?
Yes?
Sorry, Detective, I know I do it constantly here on my table.
Yes,
Unlike
sir.
my funny bone is ready to pop out.
I can understand, yes, sir.
Okay. So, Detective, that's aggressive, right?
I guess it's in the way you would perceive it. We hear cussing and yelling all the time. That could be considered, I guess, aggressive if you wanted to term it that way.
And especially when you're leaning over the back of your chair and you're within, what, a foot, 2 foot of Mr. Reeves? That's aggressive.
There again, sir, that would be, it could be considered to be aggressive.
And you would agree, would you not, that when you're loud towards someone else, it has an impact on that person?
Objection, speculation.
Sustained.
It's 7:01.
Approach.
The evidence goes. Detective, you would agree that at that point in time, you had this information from Corporal Hamilton and Angela Hamilton. At that point in time, you didn't know the distance between Mr. Oulson and Mr. Reeves while he was being aggressive, right? You didn't know what the distance was.
No, sir. I did not know the measurements.
And you didn't ask Corporal Hamilton, can you tell me, was it a foot, was it 2 feet that you were seeing? You didn't ask that of Corporal Hamilton.
No, sir, I did not.
And that last interview with Angela Hamilton on tape was 5 minutes.
That's correct, sir.
Okay, so let's. What time did you end with Angela Hamilton? Let's go there. Started at 14:43, ended at 14:57.
That's correct.
Okay. Correct me if I'm wrong. You arrived at 14:15. You started
Objection, Judge. Asked and answered.
trying to get the timeline, Your Honor.
All right, I'm going to overrule.
I'll let you tell us. You got there at 14:15. When did you first start Alan Hamilton?
227.
So 14:27. And you ended with Alan Hamilton?
At 14:38.
At 14:38. You started with Angela Hamilton, 14:43, correct? That's why I gave you the pad so we could,
Thank you, sir, I forgot.
okay.
I'm not accustomed to doing it this way. At 14:43, 2:43, and I concluded that at 2:57.
14:57, correct?
Yes, sir.
Military time.
Oh, we're going to use military, 14:57, sir.
Okay. Now, from there, you do what?
I got a hold of Detective Koenig, and we went out and interviewed Mr. Reeves.
Okay, so you left the party room,
Yes,
right?
sir.
You didn't go into Theater 10, which was a crime scene.
That's correct.
And so how did you get to the location where Mr. Reeves was at? Did you go through another theater? Did you go all the way around the building?
We walked to the back of the theater and entered the parking lot. I had obtained my vehicle, and that's where we did the interview, was in my vehicle in the
So
parking
you
lot.
went out to the parking lot, got in your vehicle, and drove it around to the back.
That's correct.
Is that correct?
Yes, sir.
Okay. Now, your purpose of doing this now was you wanted to interview Mr. Reeves.
That's correct.
And we've been fortunate enough to hear the interview of Mr. Reeves yesterday in this case, and you were present, right?
That's correct.
Okay. Now, certainly, when you first got to the point of interviewing Mr. Reeves, you now had this information, this voluntary statement that Corporal Hamilton had given to you concerning the aggression that he had witnessed, correct?
Objection to the characterization of the question.
He testified it was aggressive,
Overruled.
correct?
Yes, sir.
Okay, and you certainly were interested, were you not, in what effect that aggression would have had on Mr. Reeves?
Yes, sir.
Because your job at that point was to assess whether or not Mr. Reeves's evaluation of the circumstances was reasonable, right?
Your Honor, I'm going to object.
Approach.
So now, you were going to interview Mr. Reeves, not only with yourself, but you were going to interview Mr. Reeves with another detective present, is that correct?
That's correct.
And in this particular interview that you had with Mr. Reeves, you didn't have a pre-interview non-recorded, right?
That's correct.
You applied a different procedure for Mr. Reeves in this particular case. You recorded from the very beginning.
Yes, sir.
Okay. Now, that was done in the front seat of your car,
That's correct.
is that correct?
Yes, sir.
Okay. And is there a reason that it was done in the front seat of your car and not in the party room as the other witnesses?
Convenience. He was handcuffed, detained. I didn't want to parade him back into the theater.
Well, you brought him into Theater 11 shortly after your interview, right?
Yes, sir, but we pulled as close as I could to that door to allow him to exit the vehicle to get into the Theater 11.
And that wasn't difficult?
Sir,
That wasn't difficult?
I ran over a curb, so I was able to get up to it, yes, sir.
Okay. Now, your interview of Mr. Reeves, you turned on the recorder, right?
Yes, sir.
And you started asking him questions, correct?
Yes, sir.
And we heard that Mr. Reeves told you that he was scared of Mr. Oulson, correct?
Yes, sir. The tape, yes, sir.
Okay, so let's talk about that. When you first started your interview of Mr. Reeves, you didn't even know the age of Mr. Oulson, correct?
I knew that he was in his 40s.
Well, that's because Mr. Reeves told you. I'm saying before the interview of Mr. Reeves, you didn't know Mr. Oulson's age.
There again, sir, I believe that I might have been furnished that information as to the fact that he was in his 40s by Major Corbin and Detective Harris. I knew that he was not a older man, the victim. I now recall that they told me that he was a middle-aged man and might even have told me that he was in his 40s.
And did you know how tall he was?
No, sir.
And did you know how much he weighed?
No, sir.
Okay. And so you start interviewing Mr. Reeves. That interview of Mr. Reeves takes about 30 minutes, correct?
Goes on at 15:10, 3:10, and
Stops at 3:40?
just double check.
I've got it here if you need it.
I've got it here. That's right, 3:40.
Okay, so about 30 minutes, right?
Yes, sir.
Okay. You indicated to the ladies and gentlemen of the jury that you already knew, supposedly, that there was a phone in front of seat 9 in the theater, correct?
Yes, sir.
But you didn't know that seat 9 was the seat that Mr. Reeves was seated at, correct?
At the time that I'm interviewing Mr. Reeves,
Yes, sir.
I knew that he was on the back row. I knew that his wife was immediately to the right. I knew that Mr. Hamilton and his wife were 4 or 5 seats over to the left, and that the victim and his wife were in front of him.
4 or 5 seats? You think the Hamiltons were 4 or 5 seats to the left? What
That-
about 7 to 9 seats to the left?
7 to 9. At the time that I did the interview,
Yeah.
I wasn't aware. I knew there were witnesses on that row.
Well, you just said that you were aware that the Hamiltons were, I think you said 5 to 6 seats. It's really 7 to 9, right?
Those seats that the Hamiltons are in are not numbered on this map that I have. During my interview with them, they told me that they were 4 or 5 seats over to the left.
To the left. Okay.
According to Mr. Hamilton, he was to the north. The shooter was to the north of him, which would have been to the left.
And I'm sure that Mr. Hamilton told you as well that he was only able to see a silhouette because of the darkness in there.
I don't remember if that's the terminology that he used, but he did tell me that it was dark.
And that he couldn't actually see any facial features of Mr. Oulson because it was dark.
Are you telling me that's, who said, do that again, Counselor, please?
Alan Hamilton.
Yes, sir.
Now,
Hold on. Could you redo that question? I'm not for
Sure,
sure.
sure.
Okay.
Alan Hamilton told you that it was so dark that he couldn't see the facial features of Mr. Oulson.
Your Honor, I'm going to object.
Sustained,
There's
sustained. Move on.
Now, you knew, however, when you were interviewing Mr. Reeves, that there was a phone on the floor, correct?
Yes, sir.
Did you know whose phone it was?
No, sir.
Or did you ask anybody? By this time, I would imagine you had Detective Smith already in the crime scene, right?
Yes, sir.
Or did you ask Detective Smith, hey, can you tell me what seat that phone is in front of? Did you ask him that? Smith?
No, sir.
So you didn't know who the phone belonged to, and you didn't know what seat it was in front of?
No, sir.
But you knew that it was in the back row, which we call row A, right?
Yes, sir.
Okay. And you realized that it was somewhere in the center of that row? Or did you even know that?
I knew that it was in the center of that row, around
Okay.
the center of that row. Yes, sir.
And Mr. Reeves tells you that Mr. Oulson hit him in the head, either with a fist or a phone.
Or something. Yes, sir.
A fist or a phone, or something.
Yes, sir.
And so that must have triggered immediately a ringing of the bell. Wow. Mr. Reeves is saying he was hit with a phone.
Your Honor, I object to the gratuitous comments being made by counsel.
All right, overruled.
That rang a bell, right? Because you knew that there was a phone there in that row.
Yes, sir.
And if Mr. Reeves is telling you that, hey, I think I may have been hit with either a fist or a phone, that phone becomes paramount in this investigation, right?
It's important. Yes, sir.
Very important, would you agree?
It's important, sir. Yes, sir.
Is it not very important?
Everything is important, sir.
But this is really important, right?
It's important.
And the reason that it is important is because there may be some evidence, some physical evidence on that phone, right?
Yes, sir.
And that physical evidence could link that phone, at least the DNA on that phone, to Mr. Reeves. Right?
Yes, sir.
And if in fact it does, now you've got a piece of evidence to try to recreate what happened, right?
Yes, sir.
Because that's what you're trying to do in these investigations. You're trying to recreate what actually happened in that theater, right?
Yes, sir.
Okay. So, Mr. Reeves also tells you in that interview, not only that he was hit with a phone, but he tells you that that phone was in between his legs immediately after the shot. He realized, oh, there's the phone right between my legs after the shot took place, right?
Yes, sir.
And clearly you knew that because Alan Hamilton was the person that told you that the phone was on the floor,
That's correct, sir.
in between Mr. Reeves' legs.
Yes, sir.
And Reeves told you that it was a dark theater.
Yes, sir.
And you would agree the darker the theater, the more it affects people's ability to see.
Objection, speculation.
That's a 701.
Overruled.
You would agree the darker the theater, the more it affects people being able to see, right?
Yes, sir.
He also told you that it was extremely loud in that theater because of the previews, correct?
I don't know if he uses that terminology. He says that it was loud.
Okay, and you didn't doubt that, right? Previews are loud.
They can be, yes, sir.
And had you known by this time what the previews were?
I know, sir.
You didn't know that there were Action, RoboCop, Terminator?
Objection, facts not in evidence.
I'm asking him if you knew.
Oh, overruled.
Did you know?
No, sir.
You hadn't asked anyone there in management with the theater, hey, listen, tell me what the lighting settings were during the previews and what those previews were.
No, sir.
In fact, you never did that, did you? In your entire investigation there at the scene that night, you never even did that.
No, sir.
Now, when you realized that there was that phone on the floor, did you contact Detective Smith and say, hey, we've got to be very, very careful with that phone. We got to make sure we preserve it for DNA evidence, because Mr. Reeves just told me that he thinks he may have been hit with that phone. Did you tell Detective Smith, who was the crime scene detective, to do that?
No, sir. That was part of his training, forensic techs, his training on how to handle possible DNA evidence.
So you left it to him that you didn't know whether he had ever been assigned as a crime scene detective on a case?
He had been assigned as a crime scene detective on a case, probably not on a homicide. However, he knew the proper procedure for handling DNA evidence.
How do you know?
He's very sharp. He knows how to work a scene. I've been with him before. He knows his job.
So, grabbing the phone off the floor and turning it off the day of the incident, and then coming back a few days later and taking the phone from the evidence room and turning it off.
Object, there's been no evidence of that.
Sustained.
Mr. Reeves told you that in addition to being hit on the phone, with the phone, that Mr. Oulson was cursing violently at him, right?
I don't know if he uses the terminology violently, but he was cursing.
And that certainly was being corroborated by your previous interview of Corporal Hamilton.
Yes, sir.
Did you ask Mr. Reeves, how close was Mr. Oulson to you when he was leaning over that chair and yelling profanities?
No, sir.
You didn't ask him that?
No, sir.
I think you already testified that you didn't ask Mr. Reeves in that interview what his training was in identifying danger. Correct?
No, sir, I did not. But as I've previously testified, he could have been an ex-police officer, but in this particular case, that had no bearing on this investigation.
So you're telling this jury then that his prior training, no matter how extensive, had no bearing in this case?
Sir, as I testified yesterday, we are all human and we all have the capability of making mistakes.
No, listen to my question. You just told this jury that his prior training and expertise has absolutely no place in a case like this. That's what you just told the jury.
During my investigation, it had no bearing in my investigation.
And so you didn't consider it.
I did not.
Now, Mr. Reeves told you that he was so frightened that he was trying to create distance by leaning sideways and back on his chair, correct?
I recall him telling me that he leans back in his chair.
And that was to create distance, correct?
That's correct.
You've been a police officer long enough to know that that's one of the skills if someone's about to attack you that you want to do, correct?
Your Honor, I object. 402.
All over the rule.
Correct? It's one of the things that you're supposed to do. That is a technique, create distance.
In some situations, yes, sir, you want to do that.
You certainly don't want to get closer to the person that's about to attack you. That's a big no-no, right?
There again, sir, it depends on the situation that you're in.
Oh, so you think it's okay if someone's attacking you just to get closer to them?
There again, sir, every situation is different.
Well, this situation, do you think it was reasonable then for Mr. Reeves to
Your
get
Honor,
closer?
I object.
Sustained.
Mr. Reeves told you that Mr. Oulson told him that he was going to kick his ass.
There again, sir, I'm not sure if that was the terminology or not that he used.
We just heard it yesterday.
There again, sir, I don't recall that. Let me look. Do you have the page number there?
I can give you the whole transcript.
I've got the transcript.
Okay, well then.
I was just hoping that maybe you would have the page number. Pardon me, Your Honor, I'm trying to locate it real quick.
Not a problem. That's right. He does say that, many saying, and this is Mr. Reeves, I think that he was talking about texting his daughter. If it was any of my, there's fucking there 3 or 4 times, this ain't my fucking business.
or I'll kick your ass. Whatever he's saying, he was threatening. I'm going to be candid to you. I don't remember exactly.
So that's what he was telling you, right?
Yes, sir.
And you believed that Mr. Reeves was forthcoming to you, right?
Objection,
So,
Your Honor.
Yes.
Now, let's talk about that phone a little bit more.
Sir?
Let's talk about that phone a little bit more.
Okay,
You didn't know the weight of the phone at that point in time, correct?
that's correct.
But you would agree that if that phone was being thrown at someone else, it's being used not as a phone, but as a weapon.
It could be, yes, sir.
And you would agree that that phone can cause great bodily harm?
It could, yes, sir.
It can cause death?
It'd be difficult, but I guess anything is possible, sir.
It'd be difficult. Well, tell me why you think it would be difficult.
Judge object.
You opened the door on it, Judge.
Judge, can we approach, please?
To suggest that you can't cause death with a phone.
I have no medical training, sir,
Okay.
other than first aid.
Yeah. In fact, not only a phone, hands can kill.
Yes, sir.
And you would agree that if a phone is thrown at somebody and it hits them in the head, not necessarily going to cause an open wound, right?
It might not, yes, sir.
There's a lot of factors that you have to consider, right?
That's correct, sir.
Did you all ever weigh this phone?
Yes, sir.
Was that after we weighed it?
I believe so, sir.
And you found this phone to weigh as much as a cue ball, correct? Cue ball, like a billiards cue ball?
I'm not familiar with the weight of a cue ball, sir.
Well, if I had thrown a cue ball at you, it could cause great bodily harm, right?
Yes, sir.
It could cause death, correct?
Possibly, yes, sir.
Okay. Now, of importance was, in this case, Mr. Reeves' disabilities, right? What was his medical condition, his physical condition? You never asked him that, right?
No, sir, he volunteered it.
He had to tell you that he had arthritis, bad back, correct?
Yes, sir.
A whole slew of ailments that he was telling you he was experiencing at the time of this incident.
Yes, sir.
Did you ask him for particulars of that?
No, sir, I did not.
Meaning, Mr. Reeves, tell me what, you've got arthritis in your hand. Tell me what that does to you. You never asked him that.
No, sir, I did not.
Mr. Reeves, you've got arthritis in your shoulders and in your spinal column. Tell me what that does to you. Never asked him that.
No, sir.
Mr. Reeves, do you have difficulty getting up off a chair? What do you have to do in order to get up off of a chair, Mr. Reeves? Never asked him that.
And he never told me that. No, sir.
My question is, did you ask him that?
Oh, no, sir.
Did you ask him, Mr. Reeves, you've got these shoes that you have to kind of pull some strings there. Are you wearing those shoes for a reason? Didn't ask him that.
No, sir.
Did you ask him how heavy he was?
I did.
Did you ask him, hey, was that your normal weight while you were a law enforcement officer?
No, sir, but he told me he'd gained some weight.
Did you ask him if that was his weight while he was the head of security for Bush Entertainment?
No, sir.
Did you ask him if he had deteriorated? during the last few years?
No, sir.
You asked him what his limitations were.
No, sir.
But he told you he was a physical wreck, right?
Yes, sir.
That was important in your investigation, was it not?
As we've talked, yes, sir, everything's important.
Well, but that in particular was important, was it not?
It was important, sir.
But you didn't ask any follow-up questions at all?
No, sir, he appeared to be healthy.
Oh, is that back to your medical degree?
Judge, objection, Judge.
Sustained.
Is that because you now have the qualifications to be able to assess someone's condition by visual sight?
I can observe someone, he's able to walk around, he's not under, doesn't need a cane, doesn't need any of that stuff to get around.
So you're okay if you don't need a cane and you can walk?
Well, he didn't appear to be physically disabled.
Do you think that individuals in their 70s can perform just as easily as someone in their 30s or 40s?
There again, that depends, sir.
And that's why we have to ask those questions, right?
Yes, sir.
Did you consider Mr. Reeves' age?
Yes, sir, I knew he was 71.
Okay. And did you ask him, hey, why did you retire from Bush Entertainment, such a great position as head of security? Why did you do that, Mr. Reeves? You ask him that?
No, sir.
Pretty good job, right?
I don't like Busch Gardens.
Head of security for Busch Gardens.
I don't like Busch Gardens.
Oh, you don't like Busch Gardens?
No, sir.
Okay. And then let's talk about this eye. Mr. Reeves had told you that he had been hit somewhere in the eye area, correct? The head.
Yes, sir.
And he told you that he was experiencing some difficulty at the time of your interview. Correct?
With his eye, yes, sir.
With his eye. Now, by this time, had you interviewed Mrs. Reeves? Not yet, right?
No, sir.
Okay, that was after the first interview of Mr. Reeves.
Yes, sir, he requested, or told me that I needed to speak to her.
Okay. Now, Mr. Reeves also told you something very important, and that is immediately after he fired the weapon, he placed that gun on his lap, took his hands away, right?
He said that he put the gun on his leg and that I don't recall him saying that he moved his hands back.
Well, what did Corporal Hamilton tell you then when he came up and took the gun from Mr. Reeves's knee? That Mr. Reeves's hands weren't anywhere near the knee, right?
I don't recall him telling me that, sir.
Well, what's the issue with it?
I don't recall, I knew the gun was on his leg. I don't know if he had his hand on top of the gun. I recall Mr. Hamilton telling me that he walked over and took the gun from him, that he had it
On his knee?
on his knee.
Okay. And so you would agree, and I'm sure you've been trained in this as well, you would agree that in a situation where you're in a darkened area, you're in a theater, there's been a shooting, you certainly don't want to be displaying that weapon out to the entire group because someone else may have a gun and start shooting, correct?
That would be a very pertinent thing to do, not to display it.
So Mr. Reeves, immediately after the firing the shot, was in training protocol, putting that gun immediately on his knee out of sight.
Yes, sir, common sense.
Well, it's common sense and training, correct?
Yes, sir.
immediately after the shot took place, correct?
Yes, sir.
And you're taught as a police officer that the minute that you stop the threat, you don't keep shooting, right?
That's correct.
One shot in this case, and only one. Correct?
Yes, sir.
Okay. Training protocol is following that training.
Yes, sir.
You finished that interview with Mr. Reeves. And let's talk about the time, because I want to make sure we've got this time sequence nice and tight. What time did you finish with Mr. Reeves? 3:40. I thought you wrote it down on that piece of paper there.
I finished at 3:40.
At 3:40.
Yes, sir.
Okay, and so now you are going into what investigative mode? What are you doing now? After you finish that, you go to Mrs. Reeves, correct?
That's correct.
Okay, so let's talk. What time do you start Mrs. Reeves?
One moment, sir.
I'm sorry.
I started that interview at 16:25.
Also known as 4:25, right?
Yes, sir.
16:25. And you finished that interview at 16:38.
That's correct.
How many minutes is that?
That's 30,
I hope it's not 30.
no, 30, 45 minutes. Oh, you talking about for Miss Reeves? I apologize, sir.
Yes, that's okay.
That's 13 minutes.
You had a 13-minute interview with Mrs. Reeves.
That's correct.
And this one you recorded immediately, no pre-recording by you.
That's correct.
And she was a witness, not a suspect.
That's correct.
And so you didn't violate the protocol of the sheriff's office.
That's correct.
And Mrs. Reeves likewise told you that she was scared.
Objection, Judge, to hearsay.
Sustained.
Okay. You spoke to Mrs. Reeves for 13 minutes, right?
Yes, sir.
Okay. And so, after that 13-minute interview with Mrs. Reeves, you decide to go back and interview Curtis again, right? So let's try to take the scenario if I can. Alan, Angela, right?
Yes, sir.
Curtis,
Yes, sir.
Mrs. Reeves,
Yes, sir.
now back to Curtis, right?
Yes, sir.
Okay. And so when you go back to Curtis, what time was that? I've got it right here if that makes it easier.
16:43.
16:43. 16:43, right? Which would have been what?
4:43.
4:43. And then you finished that at 16:48.
That's correct.
Is that correct?
That's correct.
Okay. Let's talk about between 16:43 and your last interview with Mrs. Reeves. You finished Mrs. Reeves' interview at 16:38. Is that correct?
That's correct, sir.
And you started Mr. Reeves' second interview at 16:43.
According to my notes, yes, sir.
Is that correct?
Yes, sir.
How many minutes is that?
5?
5 minutes, okay. And so in between that period of time, after you interviewed Mrs. Reeves for the second time, your testimony is that you go to the command center.
We have a meeting. It's not really a center, but command center, but we have a meeting out in front of the theater.
Okay, so you have to, let's see if I can get this correctly. You were interviewing Mrs. Reeves in the same room?
I believe so, sir.
Okay, and so you have to leave that room, have to leave the theater, you got to go through the doors,
Right.
and go out into the parking lot where you had your makeshift command center, right?
That meeting occurs right there outside the front of the theater, right there in front of the box office.
Okay, and would you tell the ladies and gentlemen of the jury again the purpose of that meeting?
To discuss the case, the information that patrol deputy or detectives had received from their witnesses, their interviews.
To discuss the case. So that's a very important meeting, is it not?
Yes, sir.
Because you're trying to get information from all the various sources of witnesses that are being interviewed, correct?
Yes, sir.
And these witnesses are being given voluntary statements for them to write down what, in their opinion, they saw. Right?
Yes, sir.
And so that's a lot to look over, right?
Yes, sir.
And so it must have taken you probably, what, a minute to get from the room that you were interviewing Mrs. Reeves to that meeting up front?
Possibly, yes, sir.
So that leaves us 4 minutes. And so now, it must have taken you at least 3 minutes to go from the meeting to go back to Mr. Reeves, right?
I'm not for sure, sir, how long it would have taken.
Well, he was in the back, right?
Yes,
In a
sir.
car. And the meeting was out front of the theater.
Yes, sir.
But it'd take you at least 3 minutes to get there, right?
There again, sir, I don't know. It would have
So you
taken,
must have had a 1-minute meeting with your group outside the theater, because those are the numbers, right?
yes, sir.
A 1-minute meeting you had to discuss all of the evidence that allegedly had been uncovered at that point, right? 1 minute.
I tend to believe, sir, it was longer than that.
Well, the numbers don't add up, right?
That's correct.
And so tell me who you spoke to outside the Cobb Theater for a minute that gave you enough information for you to go back and tell Mr. Reeves that you were going to charge him with second-degree murder.
We had stood there and talked. The detectives, command staff was there. Sergeant or Captain Eckley, Major Corbin, the sheriff, Detective Harris, Sergeant Sessa, and they had said that no one had seen a punch being thrown and that no one had seen the suspect coming over the chair.
Oh, you must have told him, wait a minute, I spoke to Mr. Hamilton. He says, yeah, that, Oulson was leaning over the chair and he was yelling and he was cursing. I'm sure you told Captain Sessa that.
Your Honor, I'd object to the characterization of the question. Leaning over and coming over are two very different things.
Sustained.
What did you tell Captain Sessa about your interview with Mr. Hamilton?
Sergeant Sessa.
Sergeant, sorry.
I think we didn't go into in-depth. We didn't go in depth. We simply wanted to know if anybody had seen a punch being thrown or anything being thrown at the victim, or at the suspect. We wanted to determine if anybody thought that the shooting was justifiable.
Well, in a minute, that's hard to do, right?
There again, sir, my times could be off.
Well, times are important, aren't they?
They are.
They're critical. They're part of the evidence, right?
That's correct.
And in a homicide case especially, we can't afford to not be correct, right?
It's very important, sir.
And so, nobody saw a punch being thrown. Nobody saw a phone. That was like the deciding factor for you, right?
Being thrown.
The beam thrown.
Yes, sir.
And so, darkened theater, correct?
Yes, sir.
You don't know how dark it was because you weren't in there to see it for yourself.
That's correct, sir.
You hadn't gone back into the crime scene and said to the manager, please turn the lighting to the lighting that was present during the previews so that I can sit in this chair that Mr. Reeves was sitting and I could experience what he was experiencing. You never did that
No, sir.
before you had that meeting with, I guess it's the brass of the sheriff's office, right?
That's correct, sir.
You never went to the manager and told the manager, hey, by the way, I also want you, in addition to put the lights down, I want you to put those previews on. Because I want to sit in that chair and I want to experience whether the loudness of the previews
Your Honor, I'd object.
had any effect.
From the approach, or it's just an improper form of questioning.
I'll overrule.
You never did that, did you?
No, sir, I did not.
And did you tell the brass there at the Pasco Sheriff's Office, that, by the way, I haven't even gone into the crime scene? Did you tell them that?
No, sir. We were aware of...
Well, you may have been aware. You didn't tell them that you had not been in that crime scene. Is that correct?
That's correct.
Detective, the first time that you went into that crime scene was at 5:32 in the afternoon.
If I may.
You may, please. You want me to try to find it for you really quickly?
Yes, sir, because I don't seem to have it noted here. You have the crime scene line?
I think I do. At my fingertips.
Thank you, sir.
May I approach?
You may.
It's in the first page, Detective, very top.
There you go. Yeah, I apologize, sir. 1732. That's
Thank
correct.
you. May I have it back?
Yes, sir.
Now, let's talk about that very important process of the case, because your job's not over, right?
No, sir.
You may have told Mr. Reeves and charged Mr. Reeves at that point with second-degree murder. Let's talk about the number. Was it 2 hours, and in 2 hours and 16 minutes from your arrival, you're charging Mr. Reeves with second-degree murder? In 2 hours and 15 minutes, 16 minutes. That's why I became a lawyer. My math is... Tell me if I'm right.
About that, yes, sir.
Okay. So now, your job's not over, is it?
No, sir.
Your job now, you're going at 5:32 for the first time into this, and let me call it an incident scene, because that's what it is, correct?
Objection. I don't even know how to phrase this, improper.
It's an incident scene where the incident happened. Correct?
Overrule.
It's only a crime scene if someone's at fault. Would you not agree?
I consider it to be a crime scene.
You consider it to be a crime scene. Okay, so we'll call it a crime scene. So now you go into the crime scene, and Detective Smith is there, correct?
Yes, sir.
And you have some forensic people there as well, right?
That's correct.
You already know about the phone.
Yes, sir.
Is that correct?
Yes, sir.
But you still don't know what seat Mr. Reeves was actually in.
Pointed out that seat at that time.
Well, we're going to get to that.
Okay.
Okay. And so when you go in there, you don't know what seat Mr. Reeves was in.
I knew that it was on the back row. I knew that it was in the center, but the actual numbered seat I did not know.
Okay. And so when you go in there, do you see the phone? Do you see the phone at 5:32 in the position of that aisle?
I'm not for sure, sir, if I saw it there or if it was pinned with a pin marker.
Meaning that there could have been a pin marker there, but the phone may not have been there.
That's correct.
And so I'm sure that at some point in time in your investigation post-entry of the crime scene, that you discovered that the phone had a black case, correct?
Yes, sir.
And so if, excuse me a second, Your Honor. If I am throwing a dark object in a darkened theater, you may not be able to see it, right?
That would make sense, yes, sir.
That makes a lot of sense, doesn't it?
It would be difficult, it would be possible that that could happen.
So did you go up to Smith and say, let me see the phone? Let me see the phone. I want to see the phone.
No, sir, I knew what a cell phone looked like. We did not want to, we don't handle phones. We had photographed it, we knew where it was at, we had it pinned. They're handling the crime scene properly.
Well, you hadn't been in there, if you arrived at 2:15, you hadn't been in there for at least 3.5 hours, right?
That's correct.
And so you don't know what was happening in there with Detective Smith at the helm, right?
There again, sir, I have complete confidence in my team of forensic investigators and Detective Aaron Smith.
So let me ask you this question. So, of importance, obviously, to you was the darkness of the theater, right?
That's one of the important things, that's correct.
Okay, and so at that point in time, at 5:32 in the afternoon, did you go and get a manager to say, I want you to dim those lights?
Objection, asked and answered.
No, it's at 5:32. At 5:32, did you do that?
No, sir.
Overruled.
Was that not important at that point?
I'm sorry, sir?
Was that not important?
What?
To get those lights down, while now you're in the crime scene for the first time.
Yes, sir.
So was that not important to you?
I did not, I didn't do it, sir. At the time, I didn't think of that.
This is your only opportunity, Detective, you would agree with me, to recreate the scene that Mr. Reeves was experiencing. You could have sat in that chair. You could have put the lights on at the preview level. You could have put the previews on. You could have had someone that was 6'4" from the battalion of officers that you had there standing where Mr. Oulson was. You did none of that.
No, sir.
Well, let me ask you this. Did you get your crime scene technicians that were there in order to memorialize by cameras that very experience?
That day, no, sir.
I thought you were in charge of this homicide case.
I was.
Did you ask Mr. Smith, hey, Detective Smith, you know, we've got some lady here by the name of Amy Parrish who has had extensive training in being able to capture photographs in darkened areas. She's got some expertise in that. Let's get her to do that here. Did you do that with Detective Smith?
No, sir, not that day.
Not that day.
No, sir.
Why not that day?
I didn't think of it, sir, at the time.
You didn't think of it.
No, sir.
And was that because you had only had one case in the past dealing with self-defense, Detective? Is that the reason why you didn't do these things? Difficult question, isn't it?
I tried my best to do the very best job that I could as far as the investigation.
Detective, I don't doubt that you tried to do your best. That wasn't the question.
Right.
The question is, do you think that the reason that you didn't do these things is because at that point in time you did not have the experience in dealing with a self-defense case?
I had limited experience with that. Yes, sir. That could be a possibility.
Possibilities are dangerous in our criminal justice system, you would agree?
Yes, sir.
We can't afford to make mistakes, can we, Detective?
No, sir.
Because you have a man's life in your hands as well.
Your Honor, at this point, I would object.
Sustained. If you have much more, it's time for.
We do have quite a
Great.
bit.
All right, let's take a 10-minute recess, please. Remember my instructions during the break? Thank you.
All rise for the recess for 10 minutes.
Hey, Stephen? Hang on one sec. That new camera, all right, are we ready to proceed? Okay, Tina.
Jurors in the courtroom, Your Honor.
Thank you, Deputy. Thank you, ladies and gentlemen. Were you all able to abide by my instructions during the recess? All righty. Mr. Escobar, go ahead.
Thank you, Your Honor.
Mr. Proctor, you're still under oath.
Thank you, ma'am.
Detective, I'll keep calling you detective, I'm sorry. Mr. Proctor,
That's fine, sir.
before going back into that theater, or before going into the theater for the first time, anybody give you the name of Joanna Turner?
Not by name, sir.
Well, what did they give you if they didn't give it to you by name?
After the meeting, or after I went into the theater, there was a meeting of,
We're not there yet. I'm saying
Okay.
before you went into the theater.
yes, sir.
At 5:32 in the afternoon.
Yes, sir.
Did the name Joanna Turner, was that given to you?
No, sir.
Despite the fact that you had the meeting with supposedly all of the brass and discussing all of the interviews and all of the voluntary forms and all of that. Right?
Yes, sir.
And certainly nobody gave you a voluntary form there at that meeting with the brass that had the name Joanna Turner for you to read.
No, sir.
In fact, you didn't even read a single voluntary statement that had been given by any witness prior to going into the theater at 5:32.
The Hamiltons.
Well, that was because you interviewed them, right?
Right.
No, I'm talking about from the brass at the meeting.
No, sir, I didn't read any written statements then.
Okay. So now you go into the theater, and even though it was 2013, we are at an age where surveillance cameras are pretty common, right?
Yes, sir.
It didn't have to be 2022 for that to happen, right?
That's correct, sir.
In 2013, surveillance cameras were pretty popular.
Wasn't it 2014, Mr.
Excuse me,
Escobar?
2014.
Yes, sir.
Am I correct?
They were popular, yes, sir.
They'd been popular for quite some time.
Sir?
They'd been popular for quite some time.
Yes, sir.
And so when you went into that theater, you immediately realized that there were cameras in that theater, correct?
Yes, sir.
And so as you walked into the general theater, you looked up, there was one to your right, and there was another one to your left, right?
And Theater 10?
Yeah.
Yes, sir.
Okay. And so when you looked up and saw those cameras, you realized with all the years of law enforcement experience that you had, that video surveillance is important, right?
Yes, sir.
And when you see cameras, you're going to go and watch that film as quickly as you can.
Yes, sir.
Because you don't want that film to be destroyed, right?
That's correct.
And that film can have incredible opportunities in your investigation, correct?
Yes, sir.
And so you didn't do that. You didn't go to management at the cop theater and say, Mr. Manager, I'd like to be able to see whatever is on that film? You didn't do that.
No, sir, I did not.
And you would agree with me that you later found out that you didn't even have to go to the IT room upstairs in order to view that video, correct? You could have done it from the manager's desk.
I wasn't aware of that, sir.
You weren't.
No, sir.
It's because you never asked anybody, right?
No, sir, I'm not computer savvy. I'm definitely not video savvy. We had those people with the sheriff's office there to
Cybercrime.
Thank you, sir. We had cyber crimes there to obtain all of that.
So if you're not computer savvy, and you've got the battalion of cybercrime there, you had Bousson, correct?
Yes, sir.
You had Lindsay, correct?
Yes, sir.
You had Pepinella, correct?
Yes, sir. I'm not for sure who all was there the day of.
Those guys are really good, aren't they?
They are.
They're highly trained, correct?
They are.
They're highly trained to preserve evidence, correct?
They are.
In fact, that's why they were there. Correct?
To obtain the video, yes, sir.
Well, not only to obtain it correctly,
That's correct.
and to make sure that nobody, even the cop theater, could destroy it, correct?
That would be correct, sir.
Because when you're doing an investigation, you can't trust anybody else. You've got to put that trust only in the people that are employed by the Pasco Sheriff's Office, correct?
We'd like to have it that way, yes, sir.
And that's why they were there.
Yes, sir.
And so did you go over to Detective Bousson and say, Detective Bousson, I see that we've got some video here. I need you to go and I need you to preserve that evidence, period.
They told me that it was being preserved.
That's not my question.
Yes, sir.
Did you go to Detective Bousson, who is an expert in cybercrime, and say, Detective Bousson, you're here for this purpose. I want you to go and preserve that video evidence?
No, sir, I did not tell him that.
Well, why not?
He knows his job. That's what he does.
Well, unless Detective Smith tells him, I don't want you to do it, I'm going to handle it myself. Right?
Judge, I'm going to object. Cause for speculation on the part of this witness.
Sustained.
You would agree that Detective Smith was the crime scene detective, right?
Yes, sir.
And he had to make sure, like you, that things were going to be properly preserved because he is the crime scene detective.
That's correct, sir.
And in 2013,
14.
but in 2013, the year before, when he was in missing persons, you didn't know anything about Detective Smith as far as his capabilities in cybercrime. He wasn't in cybercrime, right?
I knew that he knew how to obtain video. He had assisted me before in robberies where he had obtained the video for me in other cases.
So he had obtained the video. Do you know what type of background he had in order to be able to do that?
No, sir. I knew that I didn't know all of his training, but I knew that he was very capable of obtaining the video.
But you would agree that obtaining the video doesn't mean that you tell the cop theater, hey, listen, do whatever you all want to do with the video and then give me a copy later on. That's not what you expected.
And I don't think that's what occurred.
My question is, that's not what you expected, right?
No, sir.
Okay, so you pretty much didn't have even a conversation with Smith about the video because you assumed that he was going to do something.
I remember the conversation occurring that the cop theater was not able to produce the video the day of the incident.
Oh, wait a minute. The cop theater was not able to produce the video, but you had cybercrime there that could extract the hard drives in the proper way and preserve the video, right? You agree with that?
There again, sir, that's above my, my knowledge. I don't,
Well, you could have spoken to Bousson and say, hey, Bousson, I guess someone in the cop theater is saying that they're not gonna turn over the videos. What can we do here? Did you have that conversation with Bousson?
I did not.
You knew at that moment that the cop theater had a liability interest of their own, right?
That would be a possibility, yes, sir.
And you certainly didn't want the cop theater to be doing anything with that video, did you?
No, sir, I did not.
Did you know that at the very moment that you had walked in to that theater tent, that the cop theater was remotely looking at the video? Did you know that?
No, sir, I did not.
So the cop theater can look at the video remotely, you're there, you can't look at the video.
It was my understanding, sir, that we could not view the video that day.
Well, was it your understanding that Detective Smith told Bousson, hey, get out of here, I'm handling this?
Judge, I'm gonna object. It calls for speculation.
No, there's no speculation about that.
Sustained, there is.
Judge Bousson is going to be testifying for me.
Okay.
Okay, so what else do you do in that crime scene, other than talk to Detective Smith for a few minutes and leave?
I also, Detective Smith gave me a rundown as to where the evidence that they had collected, the evidence they were in the process of collecting, where the victim and his wife and the suspect and his wife were sitting.
Okay, did he give you the measurements?
No, sir.
Did he give you the measurements of the seats?
No, sir.
You knew that the seats had arms, correct?
Sir?
You knew the seats had arms, right?
Yes, sir.
And did those arms move up and down?
I'm not aware, sir.
And so you left the cop theater without obtaining that video, those hard drives, that day, right?
That's correct, sir.
And in fact, you had posted, had you not, officers there at the cop theater to not allow anybody to come in to the cop theater, right?
Theater 10, yes, sir.
And you became aware that the cop theater sent an IT person from Mulberry to seize the actual hard drives that very night. Correct?
I wasn't aware of that, sir.
You're not aware of that today?
I wasn't aware of that.
This is the first time you heard of it.
I was not.
Objection, if counsel's testifying, facts not in evidence.
I'm not testifying, I'm asking if this is the first time he's heard that.
I know, but where's the facts coming from you?
Oh, it's Mr. Sillis.
I'm gonna overrule.
The first time that you have heard that a Mr. Sillis, an IT person from Mulberry, came over that night, penetrated security there at the cop theater and seized the videos is today?
That's correct, sir.
So I guess Detective Smith never shared that with you.
I wasn't aware of it, sir. He could have, but I don't remember that conversation occurring.
Well, if that had occurred, you'd be disappointed.
I wasn't aware of it, sir.
Were you disappointed now that you heard that today?
I'm disappointed that I didn't know it before I'm sitting here in front of a jury.
Well, are you disappointed that someone seized multitude of hard drives right under your nose?
I'm disappointed that I didn't know that.
Now, Detective,
Yes, sir.
you didn't know that the hard drives from the cop theater, especially all the hard drives dealing with Theater 10 and lobby and what have you, you didn't know that those hard drives had been seized and flown to Alabama?
No, sir.
Well, You didn't go to Alabama to go and retrieve those hard drives?
I did.
Well, where did you think those hard drives had come from? Thin air?
No, sir.
Object, Judge.
I would rephrase, Your Honor. Where did
Thank
you
you.
think those hard drives came from?
I was not aware that the hard drives were in Wesley Chapel.
You didn't believe that the hard drives that you were getting from Alabama were the ones that were taken from the Wesley Chapel Cobb Theater?
Yes, sir. I thought the ones from Alabama are the ones from Wesley Chapel. I understand that now, but at the time, I thought that the hard drives were being remotely, that the feed was remotely to that location.
So are you telling me that when you went to Alabama, you thought that the hard drives that you were picking up were not the actual hard drives? You thought that there were some kind of copies that were done for you at the pleasure of the Cobb Theater?
No, sir. That's what I'm saying. I'm not video savvy. I don't understand all that working. And I did not realize that the hard drives, I didn't realize that they were even in Wesley Chapel.
You didn't realize that the hard drives were in Wesley Chapel because you never went into the IT room to take a look at the surveillance equipment, correct?
That's correct.
You didn't know the make and model of the system, correct?
No, sir, but I had people there that did.
You didn't know the make and model of each hard drive?
No, sir.
You didn't know which hard drive belonged to which camera, correct?
That's correct.
You didn't know if you had multiple hard drives that were supplied by any particular camera?
That's correct.
You didn't know anything about that system.
Absolutely correct.
And so, at some point in time, much days later, right? You and Smith decide, I think we better go to Alabama.
Your Honor, will we briefly approach?
Yes.
Back to those hard drives.
Yes, sir.
You went all the way to Alabama days later, right?
That's correct.
And you went with Detective Smith
That's correct.
to go and retrieve those particular hard drives that had been in the Cobb Theater on the very moment of this incident.
That's correct, sir.
And you didn't go to just Cobb Theater management. You had to go to a lawyer's office for the Cobb Theater to go and retrieve those hard drives.
That's correct, sir.
And when you got the box or the luggage that the hard drives were in, it had a lock on it, right?
That's correct.
And so there at the lawyer's office, you didn't say, hey, lawyer, open this box so that we can see what's in it and we can inventory it and we can take photos before I am taking it back. Right? You didn't do any of that.
No, sir.
You left the box locked, not knowing what was in the box.
That's correct, sir.
And certainly you had done nothing prior to going to Alabama to go and check and see what system they had there at the Cobb Theater so that you could correlate as to whether, okay, this hard drive goes here, and this hard drive goes here, and this. You didn't do any of that.
No, sir.
And so now you're getting this box with, you don't even know how many hard drives were in there, right?
I don't, sir.
And so you get this box that was locked, and you take it with you, and you got to come. Did you fly or you drove?
We drove.
You drove all the way back to Pasco County, and certainly, when you got to Pasco County and you got to the evidence room, certainly you opened that box and said, okay, let's inventory it before it goes into evidence.
I did not.
Well, that's the proper protocol, right?
No, sir.
Oh, it's not. So you can just get a box that has nothing that you know of. I mean, it could have had 3 kilos of cocaine, and you would have known it, right?
I'm sorry, do that
I'm gonna
again?
object. Is that a
That
question
box-
or a statement?
That box could have had anything in it, and you would have never known it.
I was told that the box contained,
Well,
The
I
hard
realize
drives.
you were told that
Yes,
by
sir.
some lawyer that was representing the interests of Cop Theater, right?
yes, sir.
But my question is that you did not know before you entered that box into evidence what was in that box. For all you know, it could have been anything. Right?
Yes, sir, I was told that it was the hard drives.
Okay. And so now you put that in evidence, right?
Yes, sir.
And the person that you call on in order to image, to copy those hard drives, is the person that was at the Cop Theater the night of January the 13th of 2014, Mr. Oulson, right?
I don't know who copies those, sir.
Well, do you know that he was the one that copied those for you?
He's part of that team.
So it stayed in evidence, tell me, stayed in evidence for a week without knowing what was in there?
Sir, I don't know.
How about a month?
I don't know, sir.
How about 3 months?
Let the witness answer, please.
My apologies.
Sir, I'm not aware how long the box remained in evidence. Cyber crimes, the state attorney's office, they were handling all of that aspect of it. We had CDs of the incident, the shooting, and I don't know how long the box remained in property and evidence.
And those CDs that you had were given to you days after the incident
A couple days later, that's correct.
from somebody there with Cobb Theater, right?
Detective Smith obtained those.
Okay, do you know how? Do you know if he got it from a competent source, like a IT person, a computer engineer, a cybercrime expert?
I don't know who he obtained those from.
You don't? Okay. And so then at some point in time, though that box, were you responsible for also taking that box out and taking it to some gentleman in Orlando?
No, sir.
That wasn't you, that was Detective Smith?
Yes, sir. I went to Alabama to get it, and I brought it back with Detective Smith. We put it into evidence, and that was it. I simply accompanied him there for the long drive.
Detective, you would agree that you were not happy having to go to Alabama to get a vital piece of evidence that should have been preserved right here in Pasco County, right?
Do that again, sir? I'm sorry.
Yes, I'll tell you again. You were not happy over the fact that you had to go to Alabama to pick up a vital piece of evidence in this case when it should have been done right here by your cybercrime unit in Pasco County.
There again, sir, I'm not aware of how cyber crimes, how to obtain that. We were, that's the way it occurred. I didn't know that the DVRs were even in Wesley Chapel. There again, cyber crimes is the one that handles that. My happiness, I wanted to obtain the video.
Let me ask you this question.
My happiness has no bearing on the trip to Alabama.
Well, let me ask you a question. You certainly interviewed John Sillis, who was the IT person that came in the middle of the night and took the hard drive. You did that, right?
I did not.
Or did you direct someone to do that? Did you direct some of your detectives, hey, this John Silas, we need to talk to him? Did you direct anybody to do that?
Sir, as I've testified to earlier, I did not know that the video had been removed, the hard drives.
I have no further questions.
Thank you. Read away.
May I have a moment, please,
You
Judge?
may. Is that your pen, Mr. Escobar?
Oh, thank you, Your Honor. These are hard to, they don't have much ink in them.
Oh, right. It's a new wave pens.
I know. Thank you, Detective.
Yes, sir.
And Your Honor, exhibit.
May it please the court, counsel. Mr. Proctor, do you have a copy of Alan Hamilton's statement?
I do not, sir.
Okay.
Counsel does.
I-
I've got it. Sure. Defense exhibit, I think, number 20. Well, it's in the back. Defense exhibit number 20. Excuse me. Yeah, number 21.
For the record, it's defense exhibit number 21. May I approach the witness?
You may.
Detective Proctor, I'm going to ask that you look at that statement, not only look at it, but I'm going to ask you to read it to yourself and see if anywhere in that written statement, Mr. Hamilton stated that it was dark in the theater, and the second thing I'm going to ask you to do is see if he ever uses the word silhouette in his written statement.
If I may.
That's what.
I'm sorry, sir, but there's no mention of silhouette here?
Is there any mention of dark?
No, sir.
Mr. Garcia, I think I need to clarify for the record, obviously that has not been admitted yet.
Yes, ma'am. Now, Mr. Proctor, let's talk about notes. I think you indicated on cross-examination, based on questions from Mr. Escobar, that you take notes when you interviewed Mr. Hamilton and Mrs. Hamilton.
That's correct, sir.
and once you have memorialized your police report, you destroy those notes.
I'm going to object.
I do.
Sustained. That was.
Right. You took notes, right?
Yes, sir.
Did you write a police report in this case
Yes, sir, I did.
in reference to your interview with Mr. Hamilton and Mrs. Hamilton?
That's correct.
Did you document in that report what they had told you?
Yes, sir, I did.
Did your notes comport with the report?
Yes, sir, they did.
After the report was written, did you then destroy the notes?
Yes, sir, I did.
Was there anything different in the notes as compared to the report?
Yes, sir, there was.
All right. Now, on cross-examination, Mr. Escobar went to great lengths asking you, well, did you ask Mr. Reeves about his disabilities? Did you go into this? Did you go into that? Do you remember that?
Yes, sir, I did.
On the second interview, did you ask Mr. Reeves, is there anything else you want to tell me?
Yes, sir, I did.
Okay. Now, let's talk about on cross-examination. Mr. Escobar asked you, Mr. Proctor, did you go into the theater and did you ask him to put the manager to put the lights on and the previews on and so on and so forth, right?
Yes, sir.
Now, as you're sitting here today, Mr. Proctor, is there any way that you could have gone back in time and done everything in that theater exactly the way it occurred on January 13, 2014? And by that, I mean, have the defendant sitting in the same seat, his wife there, obviously all the other witnesses that were in that theater, right?
Yes, sir.
With the previews playing at the volume with the correct lighting at that time.
That's
No.
also speculation as to whether you could have done it or not. I mean, we'd have to bring the witnesses in.
All
Judge?
overruled. All overruled.
Right?
There's no way you can recreate it.
Okay. Mr. Escobar went into great lengths about you going in there and you sitting and seeing this, right?
Yes, sir.
Does it matter what you saw or you heard?
And
If it's you,
yes, sir.
it doesn't matter, right?
No.
Judge, I'm going to object. Move to strike. Leading.
Sustained.
Move to strike.
Rephrase.
Mr. Proctor, what's important is what the defendant saw through his own eyes.
That's correct.
What he saw, what he heard, not you.
That's correct, sir.
You have a moment, Judge?
You may.
Because I don't have any further questions of
Can we
Mr.
approach
Proctor.
real quickly?
Yes. pleased? You're probably going to be on standby. Standby. All right, Mr. Proctor, you're free to go, but if you do get called back, you have to. Okay? If you do get called back, you have to come back.
Yes, ma'am.
But-
I'm out of this area. Can you give me a day's notice?
We will, Your Honor.
All right,
Thank you.
you'll get a day's notice.
Thank you, Your Honor. It's good seeing you.
You too.
Yes. Been a while.
State?
State would call Mark Turner.
Do you solemnly swear or affirm the testimony you shall give in this call to be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Go ahead, Mr. Rosenhauser.
Thank you. Good morning, sir.
Good morning.
Can you please state your name and spell your first and last name for the court reporter?
Mark Turner, Markturner.
And you don't have to tell us exactly where you live, but what city do you currently live in?
Brandon,
All right, and back January 13th of 2014, what city were you living in?
Wesley Chapel.
Are you currently employed?
I'm retired.
All right. What did you do before you were retired?
26 years in the Air Force and 10 years in the aviation industry.
Okay, and just very, very briefly, we don't need an entire history, but very briefly, what did you do in the Air Force?
I began as an enlisted man and then went to officer training school, aviation school, and spent most of my time in the intelligence arena.
Back on January 13th of 2014, did you go to the Cobb Theater to see the movie Lone Survivor?
I did.
And who'd you go there with?
My wife.
All right. Is there a particular part of the theater that you sit in when you go to the movie theater?
I usually try to find an aisle seat up high.
And were you able to do it on that particular day?
Yes, sir.
When you went into the Cobb Theater, so you walk up a ramp to get in there, is that correct?
That's correct, yes.
All right, then you have to turn around to your left or right, depending on what side of the theater you're on. And
Yes.
you look back at the seats, correct?
Yes, sir.
All right, when you walked in, do you recall whether or not the previews were playing at that time?
They were.
Do you recall what the lighting conditions were like?
Dimmed, but you could see your way through pretty clearly.
All right, and we're obviously going to be talking about a shooting. The lighting conditions that you're going to describe now, were they the same lighting conditions at the time of the shooting?
Yes.
All right, so let's tell the members of the jury about that. Was it dark like when the actual movie is playing?
No,
All right, so there's lights on at this point.
that's
All
correct.
right, not the full house lights, but I guess as you indicated, dimmed.
Yes.
All right, so when you're looking at the entire theater, can you see the rows?
Yes.
Can you clearly see them?
Yes.
Can you see people sitting in the rows?
Yes.
How about the aisles? Clear enough to see the aisles?
Yes.
Clear enough to see the steps?
Yes.
Did you have any concern for your safety? And I don't mean like in a super dangerous way, but, walking up to go find seats?
No.
All right, did you need a flashlight from your phone or anything like that?
No, sir.
Could you see 5, 10 seats away from you?
You could.
All right, so you make your way up to where? Is it the back row?
Back row, I sat in the first seat on the aisle. My wife sat inward.
Okay, so if the screen's behind me and you're facing the theater, were you on the left side of the theater or the right side of the theater?
On the right side.
Okay, well, that'd be facing the screen, you're on the right side.
That's correct.
All right, so if you're sitting, you're all the way to the right of the theater in the back row.
That's correct.
All right. Now, when you sat down, you indicated the lighting conditions were the same as you described it.
Yes.
All right, you recall what the volume was like?
It was elevated, but you could still converse
Okay, and when you say elevated, that's coming from whatever's coming from the movie theater screen?
Right.
All right. And did you have any difficulty hearing your wife, the person you came with?
Not at all.
Did you have any difficulty hearing anyone else around you at that point?
Not so much, no.
All right. Could you hear, the chattering in the movie theater?
Yes.
Right. Could you specifically hear what people were saying, or maybe the better way is, were you listening to other people's conversations?
No.
All right. So you couldn't hear the conversation because you weren't paying attention to it,
Correct.
but you could hear that people were talking?
Yes.
I'm going to object. It's like 10
Last-
leading questions.
I understand.
Last two. Sustain.
Based on the level of the volume in the theater, did you have any difficulty hearing anyone else?
No.
All right, we're going to be talking about the shooting incident. First of all, did you know any of the people involved in the shooting?
I did not.
Did you later learn the name of the person that did the shooting?
Yes.
And what was that person's name?
Curtis Reeves.
All right. Did you later learn the name of the person that was shot?
I did.
And what was his name?
Chad Oulson.
All right. And we're just doing that just so it's easier to describe to the members of the jury who everyone is. When you first sat down in the theater, was the defendant Curtis Reeves there?
He was not.
Right. Did you see him at some point in time?
I caught him just as he was approaching my aisle, coming back from wherever he had been.
All right. Did you have an opportunity to watch him come up?
Briefly, yes.
All right. Is there anything about what you saw of him that led you to believe that he had difficulty walking?
Not that I noticed.
Okay. He didn't have a cane or a wheelchair or anything like
No.
that? Did he go by you?
He did.
All right. And did you watch him as he went down the row?
Only in the sense that I turned in that direction to move my knees out of the way so that he could get by. And of course, he was in my field of vision. I saw him go back to his seat.
Okay. Did you see him lean forward or do anything like that when he got to his seat?
Not really. I saw him take his seat. I didn't pay much attention at that time. I was just really kind of scanning the room.
Okay. And based on the lighting conditions, did you have any difficulty seeing him?
No.
All right. At some point in time after he returned to his seat, did you see any contact between him and Chad Oulson?
I did.
Okay. And what did you see at this point?
Just Mr. Reeves leaned forward. There was apparently an exchange.
Okay. And when you say exchange, could you hear exactly what was being said at that point in time during that exchange?
I could not.
Okay. You just know there was an exchange.
Right.
Is that correct?
Yes, that's correct.
At this point, did you notice whether or not Chad Oulson was standing or sitting?
He was standing.
While Chad Oulson was standing, did you hear him say anything?
I did, yes.
And what did you hear him say?
He said, do you mind? I got a message or a text from my babysitter. I'm checking on my daughter.
Could you hear the defendant say anything in response to that?
I could not.
After that response from Chad Oulson, what was the next thing you saw happen?
Well, something, I guess something was said. I saw a reaction from Chad Oulson where he reached across and grabbed popcorn from Mr. Reeves and flipped it back in his face.
Okay. And when you saw that happening, do you know where, let me ask you this, do you know if anyone was with Chad Oulson at the time?
His wife, he was with his wife.
Okay. When Mr. Oulson reached over and grabbed the popcorn,
Yes.
did you see what his wife was doing?
I did not, before the incident, all that I had seen was her hand go up to his chest as if to coax him to sit down.
Okay. And do you recall if she was standing, sitting?
My recollection is that she was sitting.
And do you know how it was that she positioned her hand? Do you recall which way it was facing?
It was her left hand and on his left side of his chest.
Okay. And do you recall, let's say that if she was wearing a wedding ring, was the wedding ring facing Mr. Oulson or facing Mr. Reeves?
It would have been Mr. Reeves.
Okay. So her hand, I'm just using myself as a demonstrative aid, would be just this way facing?
Yes.
Okay. Now prior, well, let me skip ahead just for a moment. After you saw Mr. Oulson, you said, how did he throw the popcorn?
He reached across, grabbed the popcorn, and just kind of brought it back and then flipped it, kind of with the flip of the wrist back into the face of Mr. Reeves.
What happened right after that?
Well, I saw Mr. Reeves' arm come up from his side, extend. I saw a muzzle flash and heard the gunshot, and Mr. Oulson was shot.
Was that fairly quickly after the popcorn toss?
Very, very quickly.
At any point in time, in this entire time that you're watching, do you ever see Mr. Oulson climbing over his row into the defendant's row?
No, sir.
Okay. And are you sitting in the defendant's row?
I'm in the defendant's row, that's correct.
Okay. And where is Mr. Oulson in relation to the defendant?
One row below.
Okay. And at any time did you see Mr. Oulson climbing into the defendant's row?
No, sir.
At any point in time, did you see, other than the popcorn flick, Mr. Oulson throw anything at the defendant?
I did not.
At any time, did you see Mr. Oulson punch the defendant?
No, sir.
At any time, did you see Mr. Oulson in a position where he's leaning over the chair as if to punch the defendant?
No, sir.
At any time, did you hear the defendant exclaiming or yelling anything that would give you the impression he was being attacked?
I did not.
Okay. Did you get the impression from anything that the defendant was doing, physically or saying, that gave you the impression that he was in a life or death struggle?
No, sir.
So you're telling this jury the only thing you saw was Mr. Oulson flick popcorn?
Yes, that's correct.
At any time, did you see the defendant grab his head as if he was injured or hurt in any manner?
No, sir, I didn't.
And that would be before the popcorn?
Correct. No, I didn't see anything. of
And
that
at any
nature.
time, did you see him act as though he had been injured?
No, sir.
Did you ever hear Mr. Oulson threatening the defendant?
I did not.
Did you ever see Mrs. Oulson standing in front of Chad Oulson trying to hold him back as if this raging guy was trying to get into the defendant's row?
No, sir.
After the shot, did you hear the defendant say anything?
Yes.
Okay, and what was it that you heard the defendant say?
Throw popcorn in my face.
After the shooting, did you see what the defendant did with the firearm?
He brought it back and appeared to lay it in his lap.
Okay. Did someone come up to him at some point in time and take the firearm from him?
Yes.
After Mr. Oulson was shot, did you see what happened to him?
He said, "I can't believe this," and he turned toward his row and took a step or step and a half and collapsed.
Okay. At some point in time, did you see Mrs. Oulson?
Yes.
Okay. And what was she doing when you saw her?
Well, she was hysterical, of course, and had began running up and down the aisle to where I was at, and my wife was behind me. She had been shot in the finger, and we tried to help her with that. We had some napkins and wrapped her finger up, and
Okay, so when you saw Miss Oulson, you saw her finger?
yes,
And what did it look like?
it looked like it was hanging on by the skin.
So you helped her at that point?
Tried to, yes.
All right. At some point in time, did deputies from the sheriff's office come to the theater?
Yes.
All right. Did you stay in the theater the entire time, meaning from the time of the shooting until the time deputies came into the theater, or did you do something else?
Well, I had, in an effort to help Mrs. Oulson, I had asked her if there was someone that I could call, and trying to catch up with her, we wound up down at the exit by the screen and stepped outside, and I asked her if I could call someone to help her, if she wanted to check on her children or whatever, and she said yes and gave me her cell phone and told me who to call.
Okay. The deputies eventually get to the theater?
Yes.
All right. At some point in time, were you given a form sometimes referred to as a written statement to fill out?
Yes. Well, actually, I had to go find it, but there was a gentleman in the room that people had to get the form. It was pretty organized.
How little, anything like that?
No, sir.
All right, so you just put in there the details you thought would be important?
Yes.
All right. Did you assume at some point you'd be interviewed by someone in law enforcement?
Yes,
Were you in fact interviewed by someone in law enforcement?
I was.
At any point in time, did you discuss all the details of what you saw with people that were in the theater that you did not know?
No.
Everything you're testifying to, is that what you personally heard
That's correct.
and personally what you observed?
Yes, sir.
May I have a moment, Your Honor?
You may. Lunch now, and we'll take an hour for lunch. I'll ask you to be back at about 1:45, and we'll resume at that point. All right? Remember my instructions during the recess.
All right, we're in recess for 1 hour for lunch.
Thank you. We'll be in recess as well for an hour. We'll see you back at 1:45. Oh, yeah, thanks. Thank you, Mr. Michaels. And for the record, we do have present and has been present the entire day is Mr. Scott Rosenwasser for the state, Mr. Manning Garcia for the state, Mr. Glenn Martin for the state, Mr. Richard Escobar for defense, Mr. Dino Michaels for defense, Mr. Reeves has been present the entire time, and Mr. Matt Funderburg and Ms. Lopez as well. Flores, I'm sorry. All right. Yeah, I know she's back there somewhere. And Mr. Turner, you can take a lunch as well. Just be back at about 1:45, okay? Thank you. All right.
Ready for the jury?
Yes.
Jurors enter the courtroom, Your Honor. Jurors may be seated. Jurors seated and accounted for, Your Honor.
Thank you, Deputy. Ladies and gentlemen, thanks for coming back. Were you all able to abide by my instructions during the recess? All right, excellent. We'll get started directly. You want to call Mr. Turner back in? Mr. Turner, I'll remind you that you're still under oath. Okay, still under oath. Thank you. Go ahead. Oh.
Jury's out.
Okay, I'm putting the, yes, off the record.
Jurors in the courtroom, Your Honor.
Thank you.
Jurors may be seated.
Very good. Thank you again. Just did a little practice run there and make sure you were all awake after lunch, so. All right, we're ready to begin again, and I did remind Mr. Turner that he's still under oath. Mr. Escobar?
Thank you, Your Honor. May it please the court, counsel. Good afternoon, Mr. Turner.
Good afternoon.
Mr. Turner, you're retired,
I am.
and how old were you back in January of 2014?
59.
59. Okay. You went with your wife to the Cobb Theater, is that correct?
Yes, sir.
Okay. And I believe you indicated on direct examination that when you first went in, the previews were already playing.
Yes, sir.
Is that correct?
That's correct.
Okay, and so you walked up the stairs with your wife, and you all took a seat at the very top row, which I'm just going to call it row A for identification purposes, okay?
Yes, sir.
Is that correct?
That's correct.
And so if this is the, I'm going to use this as a screen. So if this is the screen, you were all the way to the right on row A. You were seated at the very last seat.
Correct.
Of row A.
Facing the screen.
Facing the screen.
On the
Just think
right.
that's a theater screen right there.
Yes, sir.
And your wife would be to your left.
That's correct.
Is that correct?
Yes, sir.
Okay, and you normally like to sit, obviously, at the end, is that correct?
Yes, sir.
So that you can go to the bathroom whenever you need to?
It's more to be able to stretch my legs, but yes.
Okay, I know that you've had some, I guess, problems with your legs in the past,
Yeah.
is that the issue?
Yes, sir.
And were you using a cane back then or not?
Intermittently, I did.
I know you had fallen quite a few times.
Yes, sir.
And sometimes you were in need of a cane and
Yes, sir.
and sometimes not. Is that correct?
That's correct.
Okay. And so you just don't recall whether that day you had a cane?
I'm pretty sure I did not.
Okay. Now, when you went into the previews, since they were already playing, they were loud.
Yes, sir.
And when we say loud, that's the word that you've always been using in your testimony, correct?
As I recall, yes.
You haven't been using historically the word dim. You've been using loud, right? Or low. You've always said loud.
For the vocal, yes.
For the vocal?
Yes.
For the previews being loud?
Yes.
And you've always used the word dark in reference to the lighting?
No, sir, I don't believe that's correct.
You want to 2486, lines 22 through 25. Okay.
You can also do 2473 lines 18 through 22.
Yep, we're going to talk about all that here. Now, you would agree that you've used the word darker, right?
I've used dark, I've used dim, darker, yes, sir.
Okay, and so let's talk a little bit about what that means. This is not the first time you've been to a theater, correct?
Correct.
Okay, and there's a reason why the theater turns down the lights, correct?
Yes.
It's for the experience, right?
Sure, sure.
Okay, so one of the reasons why in previews they're loud, for the experience, right?
Well, that and for commercials, they're trying to get your attention. even
Forget about the
further.
commercial, I'm talking about the previews,
Right.
the previews of the movies.
Right.
They're loud because they want to get your attention to go see RoboCop and Terminator and those types of things, correct?
Okay, yes,
And you remember that on that particular day, that's exactly what the previews were. RoboCop, Terminator, they were action-packed, shoot-'em-up type of previews.
right,
And they were loud.
yes,
Now, when you first sit down, your wife is to your left.
correct.
She's seated, you're seated. And the first thing that you notice is that you notice that there's a man standing up, correct?
Yes,
And Mr. Reeves is not in his seat, correct?
correct.
And you notice this man standing up with a phone in his hand, correct?
Yes, sir.
And he's kind of seated, where Mr. Reeves would be seated, but one row below. He's standing up,
Yes,
right? And not only is he standing up, but this tall man, right?
he was tall.
It was a guy that you later came to know as Mr. Oulson. That's your recollection, right?
Yes, sir.
And he was actually facing you.
Yes.
So he would have been facing you, right? You were right. So you got a good look at his face, your recollection is.
Yes, sir.
Okay. And he was just standing up in the middle of the theater while the previews were going. You found that a little bit odd, right?
Yes, sir.
Because you certainly wouldn't have been standing up in the middle of the theater with people behind you while the previews were going, right?
I would not have.
Well, did you see who was behind Mr. Oulson as he was just standing up in the middle of the theater?
You're asking me, did I see?
Yeah, did you see who was behind Mr. Oulson?
In my row?
Yes,
Yes. At that time, no one.
no one. So those seats were all empty?
No, I thought you, behind him, that seat was empty. The rest in the row, of course, was occupied, if that's what you're...
So the one seat right behind him was empty, but what about the seat, if I'm in that back row, right? And he is here, in the lower row. Was there an empty seat here? You know where Mr. Reeves was sitting, right?
No.
Was there someone sitting here?
Yes,
Who?
his wife.
So he would have been standing up in front of his wife when you first came in. Mr. Oulson facing you with a phone in his hand.
Yes, sir.
And that's what you saw and that's what you recollect.
Yes, sir.
And Mr. Reeves was nowhere near there yet.
No, sir.
And so you're seated and you're seeing Mr. Oulson standing up, presumably in front of Mr. Reeves' wife.
Yes, sir.
And he's just standing there playing with his phone.
I don't know what he was doing with his phone, but he had his phone in his hand.
And he's facing in your direction.
Yes, sir.
And according to your recollection, he is there for quite some time
Yes, sir.
while the previews are playing.
Yes, sir.
And then, after some time passes, your recollection is that you see Mr. Reeves walking up the stairs. Correct?
Correct.
And they're the stairs that actually lead right to your seat,
That's correct.
right at the far right.
Yes, sir.
Is that correct?
Yes, sir.
You also had noticed by that point in time that you thought that there was about 70 to 75 people in the theater, correct?
That was a guesstimate, yes.
And you noticed that Mr. Oulson had this phone that was dark in color, black.
Yes, sir.
And so as Mr. Reeves comes up to you, you're seeing him, right? Pretty close to you, he's walking up.
Yes, sir.
You see Mr. Reeves and you see him walking, and he's wearing, according to your recollection, a loose London Fog waist-high jacket, light colored tan.
I think I said a light waist jacket, similar to what a London Fog would be, or an old members-only jacket or something of that nature, but it was
Long sleeves, jacket, kind of a tan area, right?
light colored, I
Yeah,
think I said.
and so you saw, well, I think you said tan, right?
I think I said light colored or tan.
Or tan, okay. And so that's what you see Mr. Reeves actually walking up the stairs wearing.
Well, to be more clear, I saw him as he approached my aisle. So it wasn't as if I was looking at him as he was walking up. He was pretty much in my face.
So
at
even
that
better,
point.
you
Well,
even got a better view of the London Fog type jacket.
well, I wouldn't say that. I would say because he was so close, I was staring basically at his midsection. So I wasn't, it wasn't as if I was seeing him in full stature.
Well, you saw the long sleeves, right?
I saw the waist jacket, or the waist,
So you mean to tell me he was right in front of you and you didn't see anything but his waist?
I saw a cross-section of his midsection as he was coming up.
Well, didn't you see him as he was walking up?
Once he approached me,
Okay. And what he told you at that point in time, as he approached you, is he said, "Sir, excuse me, I'm going to try to get by."
well, he said, "Excuse me."
Polite, right?
Yeah, politely.
Politely?
Politely.
Okay, it certainly didn't appear to you to be grumpy.
No, no.
And as he's scooting by, you're able to see more of his person, right?
No, not really.
Oh, really? So he's walking down the aisle, and you're not able to see his person. You're not able to see his back. You're not able to see his sleeves. You're not able to see any of that.
No, what I'm telling you is when he approached, said, "Excuse me," I turned away from him, facing away. He walked by me.
Okay, let's stop there for a second. I thought you just told the jury during direct examination that you turned in the direction of his seat. to let him by.
That's what I just said.
Okay, and so then
Okay,
he's passing by.
I turned, and then he was behind me, so he walked past, and he walked on down to his seat,
So if you're
passing
turned
on my right.
So if you're turned in that direction, you're seeing him as he goes to his seat, right?
Yes.
And you're able to see his full body, right?
At that point, I could see most of it, yes.
And you saw that London Fog type jacket with long sleeves.
Actually, I don't recall that I ever said he had long sleeves, but I did say it was a waist type of jacket or, yeah, I think I said a waist type.
Okay. Now, you see him actually walk to his seat, grab the bag of popcorn from his wife and sit down.
Yes,
And certainly you wouldn't think that someone that's going to his seat to grab a bag of popcorn is ready to get into a fight with anybody, right?
Speculation, or just speculation.
Sustained.
And while all this is happening, you're saying that Mr. Oulson is still standing up. He's still standing up right there in the theater. Nobody else is standing up, right?
correct,
He's the only one in the theater, according to your recollection, that is standing up.
correct.
Objection, asked and answered.
Sustained.
And as Mr. Reeves is getting close to his seat, that's when you first hear Mr. Oulson speak, correct?
He had already sat down, and there was a communication between them, and that's when I heard Mr. Oulson say, well, what he said.
You remember having a hearing here, Mr. Turner, and it was back in 2017. And you remember the following question and answer. It's on page 2494, lines 1 through 6. Remember the following question. Is it at this moment, somewhere around this moment, after Mr. Reeves had gotten close to his seat, that you first hear a voice, correct? You said yes. A voice, one voice? You said Mr. Oulson's voice. Question, and the previews were on? Yes. And the previews were loud? Yes. So before that Mr. Reeves got to his seat and sat down, as he got close, you heard Mr. Oulson speak, correct?
I don't know that it was before he sat down.
Well, you would agree that your recollection would be much better in 2017 than it is in 2022, correct?
Well, perhaps, but I guess I would ask the question is,
Well, we can't have, witnesses can't ask questions, I'm sorry, Mr. Turner.
Unfortunately.
But you can certainly give me many answers, okay? And I'll try to follow up with you with some of those, okay? So you would agree, would you not, okay, that your recollection would be better in 2017 than it is in 22, especially since you were under oath in 2017?
I appreciate that, but I'm not sure how,
You took it seriously in 2017, did you not?
as I do now.
Okay, and so would your recollection be better in 2017 than 2022 or not?
Well, it most likely would.
Okay, that's all I wanted to know.
Yeah.
Now, you're still looking around, right? You're still seeing, you have your focus on Mr. Oulson, who's still standing up, correct?
Correct.
And this is when Mr. Oulson starts to exchange his loud voices towards Mr. Reeves, correct?
I'm sorry, say that again?
That's when he starts yelling at Mr. Reeves, Mr. Oulson.
I didn't hear him yelling at Mr. Reeves.
Well, let me ask you a question. Back in 2014, January, and I don't mean this with any disrespect, were you hard of hearing back then?
No, I wasn't hard of hearing.
Okay. The previews were loud, correct?
They were the same level as they were in 2015 or 2017.
Yeah, they don't change.
Right.
The loudness was there, right?
Yes.
Okay. And it was an action-packed type of preview, as
Yes.
we've talked before.
Objection, Your Honor, asked and answered.
Sustained.
Now, you say, because Mr. Oulson was looking at you, right? And you say that now Mr. Oulson squares up. Now he's looking straight at Mr. Reeves, right?
He turns to his right. Yes,
He turns towards Mr. Reeves.
that's correct.
He squares off to Mr. Reeves's chair.
Okay,
That's your recollection, correct?
Yes.
And you would agree at that point in time, Mr. Oulson was pissed.
Yes, he was agitated, he was pissed, he was
Well,
frustrated.
Let's
I mean,
focus on,
well,
first of all, the word of pissed. That's what the word you used, right?
Yes, I've used all of those words.
However, your definition of pissed is not anger. That's what you're telling the ladies and gentlemen of the jury here, that if someone is pissed, they're not angry. Is that your understanding?
It can be. It can be frustration, it can be irritation, it can be a lot of things, but
And it can be anger, right?
well, your body language is trying to suggest something, what I would perceive to be way beyond.
Well, we're gonna
Yes.
get to body language because that's coming up next.
Okay.
Okay? But it could be anger, right?
Yes.
Is that hard to say?
Objection, Your Honor.
You know, if this is going to be about you and I, then it's, you know, I'm not sure how that's helpful.
Well, let me ask you. After you're seeing Mr. Oulson pissed, you decide, I'm going to get up. You're going to stand up, right? You decide to get up out of your seat, correct? You felt the need at that point in time to get out of your seat. Am I right?
Yes, I got out of my seat.
And you stayed standing, right?
Yes.
And as Mr. Oulson is making his statement while pissed, he's moving closer to Mr. Reeves. Correct? Closer to Mr. Reeves. Is that correct?
He turned toward Mr. Reeves, that's correct.
Is he getting closer to Mr. Reeves?
Not at that point.
Page 2499, lines 5 through 11. Question. Same hearing, 2017. Remember being placed under oath? Do you remember being placed under oath?
Yes.
Okay. Question. You realize that after Mr. Oulson is making that statement, he's moving closer to Mr. Reeves, correct? Answer, yes. So now, not only is his voice elevated, he is now moving closer to Mr. Reeves. Your answer. Yeah, he's leaning towards Mr. Reeves, perhaps a 10 to 15 degree angle.
That's correct.
Question. You don't know whether his seat, meaning Mr. Oulson's seat, bottom, is up or down. You said, I don't.
I don't.
So you would agree here today he's getting closer, and there's an angle now in the getting closer, meaning that Mr. Oulson's body is now moving in an angle towards Mr. Reeves.
Yes.
In other words, leaning towards Mr. Reeves.
The difference between what I'm saying and the way you're couching it is I've taken it in segments. He made the turn. Once he made the turn, he leaned forward. I had expected that you were going to come back with that part and ask, and I would say yes, he
Well, you
leaned
just
forward.
got it out for us. He leaned forward, right?
Right, that's,
Okay. And you're thinking that Mr. Reeves is going to get punched.
no, sir.
2499. You remember that same hearing in 2017?
I remember the entire exchange.
Remember the following questions and answer. Question. So in your mind, for the first time, you're thinking Mr. Reeves could get punched. Answer, yeah. I'm thinking that did cross my mind.
Well,
Well, let me ask you a question.
Your Honor, I'd ask the
well,
witness to be permitted to finish his answer.
he is, I'm gonna let him, but I gotta make sure that that's what he said. That's what you said, right?
I don't believe that that's all that I said.
Oh, no,
I
we're
think there's
gonna-
context there.
Okay, well, would you like to read the other couple of sentences after?
Well, Your Honor, I think instead of doing that, maybe the witness can explain what his answer is.
What is your answer, sir?
Ask me the question again, please.
Okay, that you thought at that moment that Mr. Reeves could possibly get punched?
I think I testified that I was paying closer attention because I thought that this could develop into something further. Initially, I didn't.
So you never said what I've
Let him
just...
finish his answer, please.
Initially, I didn't know if the exchange between them was because they knew each other. I didn't know if they were together. I didn't know. It was only at the point where it appeared to get more heightened that I thought something could happen here. I never expected what happened to have been actually what happened, but I certainly paid attention because there was obvious tension between the two.
Well, you hadn't heard Mr. Reeves say a peep. Up until that point, you had not heard Mr. Reeves say a peep. Isn't that correct?
That's correct.
So how could Mr. Reeves be guilty of anything if he hasn't said a peep?
I wasn't judging either person.
The only one that you heard was Mr. Oulson, correct?
That's correct.
And the only one that was leaning towards Mr. Reeves was Mr. Oulson.
Yes.
And Mr. Reeves was there quietly, not saying a peep.
Well, I didn't say that either. I said I didn't hear him say anything.
Okay,
So he could have said a lot, but I
Yeah.
didn't hear it.
you didn't hear it. But you certainly heard Mr. Oulson. That was not a problem.
I heard Mr. Oulson.
But you do see Mr. Reeves doing something important here, right? You saw Mr. Reeves trying to create some distance from Mr. Oulson as he was leaning sideways. That you saw.
I don't recall that.
2,500, 7 through 13.
You said 2,500, 7 through 13?
Yep, it's going to the next page.
I don't see that. We look at the same thing?
Yeah. Let me phrase it this way. At that moment, you're seeing now Mr. Oulson's hands reaching towards Mr. Reeves, correct?
Yes.
Okay, and so tell me how Mr. Reeves's body is positioned as Mr. Oulson is reaching now into Mr. Reeves's space. You would agree with that?
Yes, sir.
Okay, so tell me how Mr. Reeves was positioned, his body.
He was sitting back in his chair.
Okay, meaning, those chairs have some mobility, right? Not much in that back
Not
row
much
because
in
you
the
have a wall, right?
Correct.
But it has a tiny bit, right?
Right.
And so you can pull back a tiny bit,
Right.
correct? And that's what you saw.
Well, I don't know that I saw that. It's possible, but I don't know that I saw it because the chairs go back a couple of inches. I don't know that I could determine.
But clearly, at that point in time, Mr. Oulson, as he's reaching over, is into Mr. Reeves's space,
Yes, sir.
correct?
That's correct.
And the theater's still dark, correct?
The theater was dimmed and dark. It
And the
was,
previews are still playing loud.
yes.
And as you see those arms of Mr. Oulson's coming towards Mr. Reeves, that's when you hear the gun go off, right?
No, sir.
You didn't,
His arm came across and grabbed the popcorn.
right?
He pulls the popcorn back and then flicks it.
Okay.
That's,
So, other than that movement, going with his arm towards Mr. Reeves,
yes,
and then grabbing the popcorn, you're telling this jury you didn't see Mr. Oulson previous to that, maybe 8-10 seconds beforehand, trying to go over the seat, the back of the seat. You didn't see him leaning over the back of the seat then. I'm talking about 8 to 10 seconds before. You didn't see that.
I didn't see that. The leaning over of Mr. Oulson was everything to do with him leaning forward to grab the popcorn.
So, the gun goes off, is that correct?
Yes, sir.
Okay. You're still standing.
Yes, sir.
And by this time, Mr. Oulson, according to your recollection, must have been standing for quite some time, because he never sat down, right? He was up there standing up, you know,
Correct.
right before Mr. Reeves came, while Mr. Reeves was going down the aisle, the whole bit.
Objection, this has been asked and answered several times.
Sustained.
You indicated to the members of the jury that you saw Mrs. Oulson's hand on her husband's chest, correct?
Yes, sir.
And you believe that Mr. Oulson's hands were down at his side when he was shot? Yes or no?
No.
So tell me exactly where you believe Mr. Oulson's hands were at the time that Mrs. Oulson had her hand on his chest.
What I recall was when he threw the popcorn, his hands came back to here, and then his wife's hand was already up. So it came to here, her hand would have been behind his, and then the gun rings out and his hands fall.
So his hands fall after.
That's correct.
You didn't see anything in his hands, right?
No, not at that point.
In either hand, because you had a view of both hands.
Well, initially he had a cell phone in his left hand.
That was when he was standing up,
Right,
right?
that's
Okay.
correct.
And so now his hands are down to his sides, right?
They fell to his side.
Okay. And I think you've already testified that at that point in time, Mr. Oulson made that statement and then collapsed, correct?
Yes, sir.
Okay. Now, I think you also testified that you had some contact with Mrs. Oulson, is that correct?
Yes, sir.
In assisting her on various aspects, correct?
Yes, sir.
Okay. Now, you then decide to go, I believe you testified on direct that you went into the theater, to a section of the theater where there were people milling around. And you think maybe as many as 40, 50, 60 people in that area of the theater.
Yes.
And you went to that area, and in that particular area, people were talking about what happened.
People were talking. Yes, I can't say specifically. Some probably were, but I don't recall. If you asked me what they were saying, I couldn't tell you.
You can't tell me today in 2022.
I probably couldn't have told you in 2015 or 17. but
Well,
I-
while you were there with those 50, 60 people, did you have any police officer that you remember coming up to you all as a group and saying, do not talk to anybody about what you saw?
I do not recall that.
Do you recall any police officer coming forward and saying, hey, all of these 60, we're going to separate and we're going to put you in a row and you're going to have 4 empty seats in between all of you and don't talk?
No, sir.
And so you were there for quite a long time, right?
Yes, sir.
And you were concerned because things seemed very disorganized in that theater as far as law enforcement was concerned.
That was a personal opinion, yes.
In fact, they hadn't even given you the voluntary statement forms. You had to go find some officer to go hunt something down so that you could write and the others could write a statement, right?
Well, there was this officer there that apparently had brought some forms in, but he didn't pass them out, and people were having to go to him to ask for the forms so they could write them up.
Okay. And so you do that.
I do that.
And then you go to a concession area, which is outside of Theater 10, correct?
Yes,
And there's a bunch of people there at that concession area, right? And tables and what have you. And those people were talking about amongst themselves, correct?
there was talk, again, I couldn't tell you what the subject of the...
Well, they were
conversation-
talking about what had occurred, correct?
I couldn't say that.
At least that was your assumption.
Your Honor, I'd object to the
I'm not sure.
assumption. We shouldn't be talking about assumptions.
Now, how many people would you say were there in that concession area?
Honestly, I don't recall.
Quite a few.
Quite a few.
Okay, and you were in that group.
It's true.
And so you were there for some time, right?
We weren't there, I'm going to say 5 or 10 minutes.
Okay, and then you're taken to another room, is that correct?
That's correct.
And in that particular room, again, people are talking about what just happened.
Again, I couldn't say that definitively.
But you think so?
No, I think it's possible. I don't know what I don't know.
And you were in there for quite a long time.
Yes.
With how many people would you say?
I don't know, 30, 40 maybe. I don't recall.
And it wasn't a real big room.
Right.
And there was no police officer that went into that room to tell you all, do not speak about this case amongst each other.
Not that I recall.
And there was no police officer that moved you into different corners of the room so that you all would not have access to each other.
Not that I recall.
If I may have 1 second, Your Honor. You believed that day, while Mr. Reeves was seated in his seat, and Mr. Oulson was yelling and moving in his direction, you believed that Mr. Reeves was in the most vulnerable position, correct?
Well, just to be clear, I didn't hear any yelling, but I recall this question from previously when you asked me, and it led to him being in a vulnerable position because he was seated.
Yeah.
Yes, if you're having someone over you, then yes, that's a vulnerable position.
I don't have any further questions.
Can you redirect?
Yes, Your Honor, thank you. On several different occasions, the fence kept going back to a single word description, and the single word description was dark, and the single word description was loud. So instead of focusing on the single word, every time that you were referred to, dark, dim, dimmer, darkest, whatever the adjective was the lighting condition sufficient enough for you to see in that theater?
Yes,
When we hear loud, okay, was it so loud that everything was deafening inside of this theater?
no,
And just for the sake of argument, we're hearing about different movies playing. So is there a break between different previews where it's not loud at all, actually?
Yes.
And you were asked to assume, and we probably both agree it's not a good idea to assume in court. Would that be a fair statement?
I would hope so.
Okay. And so you don't know for a fact that people were in fact discussing anything about what they may or may not have seen inside the theater.
I do not.
And you were asked about how many people were in the area. Did you hear people generally just talking?
I heard some talking, yes.
Okay, but you can't say specifically what they were talking about.
Chatter.
I'm gonna object this.
Could you hear what they were specifically talking about?
No.
Did you see or hear anyone get together and compare notes about what they observed in the theater?
No, sir.
Did you see or hear any people getting together to conspire to make up a story against the defendant here?
No, sir.
May I have a moment, Your Honor?
You may.
Nothing else. Thank you.
Just two questions.
All right, we're not going to do that every time. The state called them, they get the last word.
So since you could see so well in there, the one thing that you can tell this jury that you're 100% certain of is that Mr. Oulson was standing the entire time.
Your Honor, I object. We've probably done this 5 or 6 times.
Sustained.
In fact, I stipulate that it was true based on the 5 or 6 times you said it.
May this witness be released?
We'll keep him on standby. Your
All
Honor.
right. Mr. Turner, you're free to go, but if you get a phone call asking you to come back, you'll have to come back, okay?
Thank you, ma'am.
Thank you. Who's next?
You're on a statement called Derek Friedhoff.
Do you solemnly swear or affirm the testimony you shall give in this cause will be the truth, the whole truth, and nothing but the truth, so help you God?
I did.
Okay, thank you.
Go ahead, Mr. Rosenwasser.
All right, good afternoon.
Hi, good afternoon.
Can you please state your name and spell your first and last name for the court reporter?
Yes, my name is Derek Friedhoff. My first name is D-E-R-E-K, and last name is Friedhoff, F-R-I-E-D-H-O-F-F.
All right, and can you turn to the members of the jury and tell them what you do for a living?
Hi, I'm a registered nurse. I work with Advent Health.
Okay. And back on January 13th of 2014, were you a registered nurse at that time?
I was.
And were you working at the same location or a different location?
At that time, it was a different location.
All right. On that particular date, did you go to see the movie Lone Survivor at the Cop Theater?
I did.
And do you recall just approximately what time it was that was starting?
I believe it started approximately around 1:20.
Okay. And who did you go to the theater with?
My girlfriend at the time.
All right. When you arrived at the theater, did you purchase tickets?
Say that again?
Did you purchase tickets?
Yes, we did.
Do you remember if you went to the concession area or not?
We did not go to the concession. We went straight to the movie theater.
All right. Do you recall where it was that you sat in the movie theater?
Yes.
At the time that you were sitting down, do you recall what the lighting conditions were like?
It was dim, but you can still see where you were walking or where you were going.
Did you have any concern when you walked into the theater that you could not see where your seat would be?
No concern.
Did you have any concern that you would trip and stumble and fall on people because it was too dark?
Nothing of that sort.
When you walked into the theater, could you see the rows clearly?
Yes.
Could you see people in the seats?
Yes.
Could you see the aisles?
Yes.
Was it dark like it is when the movie starts playing?
No.
All right. Did there come a point in time when you became aware that there was a shooting in the theater?
Yes.
And did you later learn the name of the person that did the shooting?
I did.
And what was that person's name?
The name of the shooter was Curtis Reeves.
All right. Did you learn the name of the person that was shot?
Yes.
And what was the name of that person?
Chad Oulson.
All right, did you know either of them?
I did not.
All right, so we'll just refer to them by name, so when we talk about it in the positioning of the theater, it'd be easier. Let me ask you this. Do you remember what row it was that the defendant Curtis Reeves was sitting in?
Yes, I believe he was sitting in the farthest row, the very far back one.
Okay, so the last row.
Yes.
Where was Mr. Oulson sitting in relation to where the defendant was sitting?
He was sitting in the row in front of him.
Okay, where were you seated with respect to Mr. Oulson?
In respect to Mr. Oulson, I was one row ahead to the left. So if I'm Mr. Oulson sitting in this chair, I'd be one row ahead towards the left.
Okay, and then said another way, I know it's going to sound silly, is that if you looked over your back right shoulder, you would be seeing the Oulsons.
That's correct.
All right. Was Chad Oulson with somebody?
He was.
Okay, do you know who that person was?
Yes.
Who was that?
Nicole Oulson.
Okay, and you learned about her later on, meaning you learned her name later on?
That's correct.
You didn't know her prior to
I
that?
had no idea until afterwards.
With respect to the time that you sat down, do you remember if the Oulsons were there first?
I didn't notice them or anyone till later on.
All right. Did there come a point in time when your attention was focused somewhere in the theater?
Yes.
All right, so let's talk about the lighting at that time. Is the lighting the same as what you were describing before?
Yes.
All right. And what about the volume in the theater at that time?
It varied. It depended on what was either on the previews or if there was no previews at the time. Like if it was in transition, there was nothing come out of speakers. So it varied depending on what was on the screen.
Okay. Did you have any difficulty hearing the person you were with?
The person I was with, no.
All right. Could you hear other chatter within the theater even though the previews were playing?
Yes.
Could you specifically hear what other people were saying?
Unless I focused on it, not really.
All right. So the reason you couldn't hear it was because you weren't paying attention to them because you really had no reason.
Right.
Sustained.
What was the reason? Thank you. What was the reason that you couldn't specifically hear what people were saying?
I wasn't interested.
All right. What first brought your attention to someplace in the theater?
I heard some bickering coming from behind me on my right side.
Okay. And would that be the area where the Oulsons were?
Yes.
Okay. And would that be the same general area where the defendant was?
Yes.
All right. When you say bickering, how many voices did you hear?
I heard two.
Once you heard that bickering, what did you do next?
I just kept my focus on that area because it just seemed out of the norm. And then until it went away, I went back looking at the screen.
Okay. So when you looked over, tell the jury what it is that you saw.
So when I initially looked over, I saw, is it okay if I visually show?
Sure.
I saw Chad Oulson, his body was facing the screen, or he had a cell phone out. I saw the screen illuminated, and it looked like he was talking to someone behind him.
Okay. So the way you're positioned was his body at that time, other than his head, facing the screen?
Right.
Could you hear what was being said?
I could hear them talking, but I couldn't hear exactly what was being said.
After you heard the talking, what's the next thing that you remember seeing?
So the next thing I saw was someone leaving from the top row, going down the staircase towards somewhere. And then once I saw that, the bickering stopped, and then I just started watching the previews again.
Okay, so once you saw someone leave, it was quiet again.
Correct.
Did you see that person come back?
I did not.
Did something bring your attention to that area again?
Yes.
And what was that?
It was the bickering resumed. It
All right.
continued again.
And did it sound like the same voices from before?
Yes.
Did it sound like the voice of one person or two people?
Two people.
Could you tell if they were male or female?
I could tell they were male.
Both of them?
Yes.
And prior to that, when one person had left, it was quiet.
That's correct.
When you heard this bickering, again, what did you do?
So it caught my attention, so I continued to look over in that area again, where the bickering was coming from.
Okay, and what'd you see?
So at that point, I saw the outline of a person stand up and then say something along the lines of texting my daughter. There were some other words where I really couldn't understand what was said, but it was like an annoyed voice, like texting my daughter.
Okay, and who was that person?
That was Chad Oulson.
And were you looking over in that area then at that time?
I was.
And then what'd you see happen next?
So almost immediately after that, I heard something, it's like something being crumpled, and then I saw like movement of something being like something, can I act it out, is it okay?
Sure.
I saw someone stand up, say something, text my daughter, and then like they reached to grab something and then thrown.
Okay,
So it was something being crumpled, I didn't know what it was at the time.
okay, and then what happened right after that?
Immediately after that, I heard someone say something along the lines like it's like it was mumbled, like they were mumbling. It said something like "show you," followed by like throw popcorn at my face. It was like more like declaratory, like out of anger.
Okay, and was it the same voice that mumbled and said throw popcorn?
Yes,
All right, so it was, the mumbled part was from the same person that said throw popcorn in my face.
that's correct.
At any time prior to the movement that you indicated, and you heard the crumbling,
Correct.
did you hear anything that sounded like a life or death struggle happening?
I did not.
Did you hear anything that would lead you to believe that the defendant here was being violently attacked?
I did not.
Did you hear anything from anyone yelling words, and it's going to sound silly, like, ow, oh my God, this is terrible, anything that would give you the impression that something is going on?
I did not hear anything of that sort.
Okay. Did you hear anything physical, like if someone were to try to jump over a seat in a theater and the seats would pop up? Did you hear anything like that going on?
Nothing of that sort.
Did you ever get the impression prior to the crumpled sound that you heard that there was a struggle happening?
Other than that, no.
Did you ever see Mr. Oulson throwing an object, a cell phone, anything at all prior to...
Nothing. I only saw that one movement of something being thrown, the initial,
Okay. And that was the crumpling.
the crumpling. Yes, sir.
Did you hear the sound of the gunshot?
I did.
All right. And what did you see after that?
So once I saw the actual gunshot, I saw the muzzle flash and I heard the gunshot. My initial was focused on that area, and then I looked away to see like where the exits were in case there was a continuous shooting. So I looked away, see where the exits were at, looked over, and then I saw someone collapse.
Okay. What did you do when you saw that?
I waited a couple more seconds because I wasn't for sure if someone was going to continue firing. And then once I felt like it was safe to go, I went to go assess whoever was shot.
Okay. And then who did it end up being that you were assessing?
Chad Oulson.
All right. So tell the members of the jury what it is that you saw when you walked over there.
So my initial reaction was, of course, I want to make sure it was safe before I went over to check on Chad. So once I saw that there was no more shooting and that there was no more any type of violence occurring, I went to Chad's side. It was still a little bit dim. I saw blood coming from his shirt, and then at that point I called 911.
Did you lift up his shirt or look at him?
I did, yes. So I initially looked for an exit wound. I didn't see one. I just saw the initial entry wound. And then once I saw blood starting to pool, I lifted his shirt up, took my shirt off to apply pressure.
Okay. Did you do anything else to try to help Mr. Oulson at that time?
At that point, I was on the phone with 911, speaking with the operator, and I was trying to assess Chad's condition while at the same time speak with the 911 operator.
Okay. And what were you seeing from Chad?
So at that particular moment, Chad was still breathing. He had some like involuntary movement, and it sounded like he was trying to breathe. And at that point, I was just trying to keep an eye on him, make sure he, wouldn't go into either shock or get worse. So we're just holding pressure while I'm on phone with 911. And as the 911 call progressed, I noticed that Chad's pulse started to decline, and I could no longer feel a palpable pulse on his wrist. So where I was at, I wasn't in a spot where I could do CPR properly. So there was someone at, I believe, at his feet, and I asked if anyone could do chest compressions while I was on the phone with 911.
So there are other people that were helping you?
There were the people that were helping me, yes.
Was there a point in time when deputies from the Pasco County Sheriff's Office arrived at the scene?
Yeah, about 15 or so minutes later.
Okay. And were you still in the theater when they came in?
Yes.
Was there a point in time when you were given a piece of paper that some people call a written statement to fill out?
Yes.
Did they give you any instructions about how to fill that out?
They just said just fill it out. There was no clear, concise way to fill it out. They just said just fill out what you saw, and that was pretty much it.
Okay. And did you assume that at some point you talked to a detective or a
Yes.
deputy? Did you in fact talk to a detective or a deputy?
I did, yes.
When you were in the theater, did you talk to anyone other than law enforcement about what you observed?
No, I did not.
Did you get together with anyone to conspire to make up a story?
No, I did not.
Are you testifying to what you personally observed
Yes.
and what you personally heard?
Yes.
Did you ever hear anyone yelling, no, 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 or whoa, whoa, whoa?
Nothing of that sort, no.
May I have a moment, Your Honor?
You-
When you were in the theater, was the only thing that you heard Mr. Oulson say was something about texting his daughter?
That's correct. That's the only audible thing that I heard.
Okay.
Like I said, he was talking prior, but I could not understand what was said.
Okay, so you didn't hear any loud threats towards anybody else?
I did not.
I don't have any further questions.
Go ahead, Mr. Michaels.
All right, at the time, January 2014, January 13th, you were a registered nurse,
That's correct.
and you worked in trauma at the time, right?
That particular time, no, I was doing neurology and orthopedics.
You worked trauma previously, right?
Previously, yes, that's correct.
And you're pretty exact because you actually purchased your ticket at 1:16 p.m. that day, right?
That's correct.
And you actually entered the theater, you remember, at 1:19 p.m., right?
Yes, because I looked at my cell phone prior to getting to the movie theater.
Okay. And so what happens is when you get in there, you describe where you sat, and your then girlfriend, Jenny Monero, was sitting next to you,
That's correct.
and she was to your right.
I believe she was to my right.
And so when you're looking back at where Mr. Oulson and Mr. Reeves are, and Mrs. Reeves and Mrs. Oulson, you have to lean back in your seat, right?
Yes, the seat reclines a little bit at the movie theater, so I was able to look past behind her head and see what was going on behind me.
All right. So you answered my question. I was going to ask if you have to look behind your girlfriend's head to look back up, right?
That's correct.
Now, what you heard that was audible to you was loud enough to be concerning to you, correct?
It caught my attention.
Okay, and it was concerning to you,
It seemed out of the norm, so it caught my attention.
okay? So are you telling me that I'm mischaracterizing what you thought? You don't think it was concerning at the time?
It caught my attention. Like, it just sounded like two people, like, bickering and arguing. Like, it just seemed, like, out of place.
I'm asking you a direct question.
Objection, asked and answered.
Okay, page 2477, line 23. I'm sorry, 2427. Lines 20. It's like line 23. Okay. This was a hearing back in 2017 that you were present for and testified in. Remember that?
I recall being here at some point in the past. I don't
Okay,
remember
the same
exact date.
courtroom,
Okay.
right?
I don't know if it's the same courtroom. I really don't know if it was A, B, C, or D.
You remember testifying
I remember
regarding this
testifying
case?
at some point in the past.
Okay. You remember it 2017?
I remember the year. I don't remember what date I was here.
Okay, that's fine. So you remember in 2017.
Okay.
There's a court hearing like this where you faced the clerk and raised your hand to tell the truth. You remember that?
I'm probably sure I had to.
Okay, well, you remember that you walked into the movie theater at 1:16 that day. Well,
I didn't walk in the movie theater at 1:16.
I'll overrule.
you bought your ticket at
I
1:16.
bought the ticket at 1:16.
And so that's even more accurate. So is there a reason why you remember when you bought your ticket, but you don't remember whether you faced the clerk and swore to tell the truth in 2017 in this courtroom?
Because I still had the movie stub, the movie ticket stub.
How do you remember that you walked to the theater at 1:19? Does
Because I-
that somehow indicate on the movie stub?
Because I looked at my phone prior to going to the movie theater. I wanted to make sure that we didn't miss the previews.
Did you look at your calendar before the hearing in 2017 and know what date it was?
No.
And so you're saying that you don't remember whether you took an oath to tell the truth or not that day?
I said I recall, I just don't remember what the date of taking the oath was.
Okay, so now, because I asked you before, so let me just ask you the question again. Do you remember facing the clerk, raising your hand, and swearing to tell the truth?
Yes.
Okay. The context is, I'll start at line 1. Question, when you first heard the bickering, could you hear what was being said? Answer, line 3, most of it was inaudible, but at one point,
Your Honor, I reject. You're going beyond what your question was. I think your question is 20 to 23, or 20 to 25.
I'll be happy to go to that section. If I'm asked to put it in context, then I'll do that, Your Honor. It's not a problem. Page 2427, line 20, question, and that's at the hearing. And you indicated that you were kind of leaning back in your chair and looking to your right. Answer, that's correct. It was loud enough to raise to be concerning to me. Right, so you were concerned.
Concern. I would agree.
And that's when you saw the light of the cell phone.
Correct.
Is that right?
Yes.
And you showed the prosecutor, you kind of gave an example where you were holding, you showed in your right hand a cell phone.
That's correct.
So do you know whether it was in Mr. Oulson's right hand, or you just,
So when I saw the cell phone,
Right.
it was kind of like just hovering. So I just saw like just a cell phone illumination, and I just saw Chad talking to someone behind him.
The question is, you held up your right hand because you wanted to do a physical demonstration for the court, or whomever. You held up your right hand. So is your testimony it was in his right hand, or do you not know for
I
certain?
believe it was in his right hand because I saw the cell phone screen. So it'd be kind of hard if it was in his left hand for me to see that illumination.
Okay. Did you see it in his hand physically?
I saw his cell phone. It's not going to float magically, so someone would have to be holding it.
Okay. So did you see my question
I
is
saw the
again,
cell phone.
Mr. Friedhoff, listen. We need to be able to allow me, number one, to finish asking my question
Okay.
before you answer. This lady here takes down every word on that machine. She cannot take it down if we're both talking, okay?
Okay.
Thank you. And so, my question is, did you physically see it in his hand?
Yes.
Okay. And did you physically see it in his right hand?
Yes.
Okay. And that's your sworn testimony?
That's my sworn testimony.
Now, during the second preview is when you heard that second part of the bickering with the texting my daughter sort of thing, right?
That's correct.
The second preview was, I think, sabotage. Do you recall that?
That's correct.
Oh. And that's when you described this whole, you heard the crumpling of something, right?
At some point, I heard the crumpling, yes, but it may not have been during that exact preview. I just
Okay.
remember the second bickering occurred during the second preview. It didn't last the entire, or it wasn't like from the start to the beginning of the second preview. It occurred during the second preview.
Okay. My question was to you, did that occur during the second preview?
I want to say it was towards the end of it.
Okay. The question, listen closely to the question. I'm not asking you when or in what part of the preview. I'm asking you, did that crumpling that you described happen during the preview?
I believe it was after the preview. The bickering occurred during the preview.
The crumpling that you heard, I'm talking about the
The
crumpling,
crumpling itself, okay.
happened during the preview.
It happened after the preview,
After the first preview?
after the second preview.
So the second preview is over, right?
Correct.
Then you heard the crumpling.
That's correct.
Now, when you look back in the row, what you see is you can't actually make out Mr. Oulson, but you see a silhouette, right?
I see a person standing, but I can't make out what they were wearing.
It appears to be a silhouette to you.
More of a silhouette, that's correct, an outline.
And then what you see is you see somebody going forward with full momentum.
They were reaching for something. It looked like they went to go grab something, and then I saw the motion of something being thrown back.
And when it gets thrown back, you see the person at full momentum.
They were just not, when I say full, I say their arm at full momentum. I don't see their full body at full momentum. I just see something being thrown.
The arm is at full momentum.
Yes, they were throwing something.
Okay, let me ask you the question again.
Well, Your Honor, I object. He answered exactly what he was being asked.
The question is, it's a yes or no question.
Well, I object. If the witness needs to explain, I ask him to have the ability to explain.
Sustained, move on.
Your Honor, cross-examination, I can call for a yes or no answer. I disagree with the prosecutor.
I would object.
So describe then how you saw the popcorn being thrown?
I saw the person standing, looked like they reached over to grab something. I heard something being crumpled, and then it was this forward motion of something being thrown back at them.
And you have any other description of how that was done?
As far as they stood up, I heard texting my daughter, and at that point, I saw someone reach over, heard something being crumpled, and then saw movement of something being thrown back at them.
Okay. Page 2451, line 20. Same hearing. Question. Then the third thing that you observed is a movement or a motion of something being thrown. Answer, your answer. Full forward momentum.
Okay.
Well,
That's your answer?
well, I would, here's my objection. I would ask that you read
Your Honor, if he's gonna do a speaking objection, we're gonna have,
Okay.
I don't know what the legal objection is at this point.
Rule of completeness, read the entire sentence.
You want to come up?
I want to make sure I read your entire answer, okay? So let me ask the question again. I'll read you the question. You're under oath. You're in sworn testimony during a hearing. Question. Then the third thing that you observed is a movement or a motion of something being thrown. Answer. Full forward momentum. I couldn't see what was thrown, but I saw movement of something of like an arm reaching out and then heard something impact, right? So the full forward momentum that you're talking about, right, is when the arm is going back.
I didn't see a pinch.
So what's full forward momentum?
Full forward momentum is you just see something moving forward,
Well, why is it full forward momentum?
because it was full. It wasn't like it was done. It would look like someone reached over, grabbed, brought it back, and then thrown. That's forward, like it had intent to throw something.
Okay. And so full meaning what? Like, let's say it was, what's slow, no momentum, half momentum?
But maybe
full
no momentum would be like that. This was grabbed, brought back, thrown.
All right, so not a flick, in other words.
Not a flick.
All right, now let's talk about some of the things that happened afterwards. Now, before the shot rings out, you hear throw popcorn at me or something to that effect, before the shot.
Something along the lines of sounds like it was mumbled. Mumble, it was hard to understand, but it sounded like show you, throw popcorn at me. And the throw popcorn at me was more out of like, it was a raised voice, and it sounded like it was out of like anger,
Okay.
annoyance.
And then the shot.
I believe the shot came as he was saying that.
Okay, so Mr. Oulson throws with full momentum. In this case, now we know it's popcorn. We didn't
Okay.
know what it was then. Into Mr. Reeves' face, right?
I didn't know where it landed on Mr. Reeves' face.
Okay. Towards Mr. Reeves. Teacher throw popcorn at me, then bang, right?
I heard show you, throw popcorn at me, and I believe he shot while he was saying that.
Okay,
So I
so-
heard show you, gunshot, then after that, throw popcorn at me.
All right, let me ask you this question. Is it, again, I need to know exact. This is a court of law.
Okay.
You're testifying as a witness. You've sworn to tell the truth. It's a truthful answer if you don't know the answer, or if you're not sure of the answer. You're telling me you're sure of the answer, so I want to know what the answer is.
Okay.
Did you hear the statement regarding I'll show you or to throw popcorn at me before the shot or not?
It was at the same time.
So it wasn't before the shot.
It was maybe a second difference. One, it was so close in time as far as when it was said and when the act occurred. It's really hard to recall exactly. It was maybe a half a second or a second within each other.
Okay, I'm concerned because I'm a lawyer, and so I don't want it to seem like I'm picking on you.
Okay.
But my concern is I'm asking you a question and I'm not getting an answer.
Your
I
Honor,
want to
he
know.
gave the best answer he possibly could.
Okay, bond hearing. Page 38, lines lines 16 through 23. I'm sorry, that's 383, lines 16 through 23. That's one of them. Let's start at 383, that's fine. 383, lines 16 through 23. You remember the bond hearing? That was February, about a month after you were at the theater that day. You remember coming to court then, soon after that?
That was at the office upstairs, correct?
No, that was a bond hearing, again in court,
Okay.
right after that, within weeks.
Okay, I don't really recall the time, but I remember coming in for something along those lines, yes.
Well, do you remember having a court hearing with a judge and everything?
Is this the same one before as the one you described? Like coming in to testify? Is that the?
Yes, yes, approach.
Here's another question and answer under oath at any rate, okay? All right?
Okay.
Question. The one statement that you attribute to Mr. Reeves that you indicated it was something like throw popcorn on my face was after the shot or before the shot? Answer, before the shot. Question, so before the shot, you hear him say, throw popcorn in my face and then the shot? That's correct, right? You remember saying that?
I remember saying something along those lines. That's correct.
Those exact words.
If that's what the statement says, that's probably what I said.
All right, let's talk a little bit about what happened in the theater that day. Now, after, first of all, after the shot rings out, you eventually make your way towards where Mr. Oulson is.
That's correct.
When you get there, there's already a gentleman that's applying compression to Mr. Oulson's chest, right?
It was dim, as far as I couldn't exactly see what he was doing, but there was someone at his side.
Okay.
I think he was applying pressure over his shirt, but I don't, because his shirt wasn't up.
Okay, well, you don't remember exactly what was happening, right?
I just remember someone being at his side.
Pardon me?
I just remember someone being at Mr. Oulson's side.
Did you see somebody actually putting their hands on Mr. Oulson's chest?
I can't recall.
All right. If I show you something, would it help you refresh your recollection?
Sure.
Okay, deposition, page 60, line 25. May I approach?
You may.
All right. All right, Mr. Friedhoff, if you would, this will help you refresh your recollection. You can sit down, please.
Okay.
Start at line 18 and work your way through the next page, please, okay?
Just
Okay,
read
read the
it.
whole page or?
To yourself.
To yourself.
Okay.
Let me know when you're ready.
Okay.
All right? May I just
Yeah.
So now you're able to look at that deposition. You remember now there was somebody else there attending to Mr. Oulson, right?
Yes, after reading that, I agree with that.
A gentleman in his 30s.
I think maybe 30s, 40s. He was older than me.
Okay. And at the time you were 20-something?
I was 23 or 24.
All right. And that gentleman, did you know that that was Matthew Reeves, Curtis Reeves' son?
I did not.
At any rate, you took over from him, is that right?
That's correct. The chest compressions that he was doing, they didn't seem adequate.
All right. And so what happens next after you're finished with that, at some point, police take you to a room and swab you for DNA and kind of process you a little bit and have you clean up, right?
Yes, I believe it was the activities room near the concession stand.
Okay? And I know you talked to the prosecutor about giving a statement, but what happens in between is that you are actually taken with a group of other people, or at least directed to an area down by the front of the theater where the movie screen is.
Yes, I recall I don't know if it was a detective or a police officer. They told us to wait in an area here and don't talk. I remember they said, don't talk about what you saw, but you can just hang out in this area.
Okay, and they may have said that, but the truth is that you actually heard people talking to each other about what happened.
I heard someone say out loud said something like they were brave about the people who went in to help. But other than that, I can't recall anything that was said other than that.
Okay, let's talk about that. So when you got there, they were talking to you and your girlfriend, Jenny Monero, at the time, and they were saying, you're brave, you're a hero.
We were away from the group. I remember seeing maybe about 6 people in the group, and then there were other couples that were kind of to themselves away.
Okay, and so your testimony today is that you don't remember whether other people were talking or exchanging views about what happened.
I can't recall what they were saying.
The question again, we'll get to that second part. The question is, do you recall people, as you were in that group, waiting for police to interview you, do you recall people exchanging views of what happened?
No, I do not.
Let me show you your deposition. Maybe that will refresh your recollection. You think that sworn testimony would help you?
Sure, visually it would help.
Okay. Page 71, I'm going to direct you to lines 9 through 13.
Said 9 through 13?
Yes, sir. 9 through 13. Let me know when you finish reading it.
Okay.
So you will agree with me that people in that group were exchanging views about what had happened, right?
What I heard from the group initially was they said that the nurses were brave about what happened, and that was it. I don't know anything else other than that. I didn't hear what else was said.
Okay, you read your own testimony.
I did.
So now you remember?
I saw what I said, but I don't know what else was said other than that. So
Then what?
Other than those nurses were brave.
Okay, so when you say that they were exchanging their views about what happened, you were talking there about nurses being brave, right?
That's correct.
Okay. And nothing else?
I can't recall anything else that was said other than that.
All right. If you can't recall, let me try to refresh your recollection again. Same deposition, page 71. This time go to lines 1 through 5.
Okay.
So now you remember that you heard people talking about what they observed, right?
I recall, other than that the paper that you provided for me, the only thing I recall was talking about the nurses being brave.
Okay.
I don't recall that part of the conversation, but if it's documented, it's documented.
All right. You deny it?
I'm not denying it.
So you agree that what you said was
Your Honor, I
that,
object. He's already asked an answer to this.
okay? And you, Judge, I'm asking, we're talking about what he said.
Go ahead.
What you said is that the people were talking, and what they said was, I think it was over popcorn, something like that, right?
Okay.
Did you say that?
If that's what's written down, it's what I said. I don't recall saying that. I mean, I can't remember saying that, but if it's written down, it's written down. I must have said it,
You remember walking into the theater at 119?
because I looked at my
I
phone.
object. This is an asked answer.
Sustained.
You don't remember giving that sworn statement because it's different?
I didn't say it, I just don't recall exactly everything that I said.
So then to say that the only thing people talked about was that you were a hero is not true. You don't recall everything,
That's
right?
right. That's from today's perspective. The only thing that I recall, what you asked, is about the nurses being brave. That's all I remember.
And then now that you see your statement, now you can see there were other things as well.
Sustained.
All right, let's talk about something else. Now, once you're there in that group, people are obviously talking about what happens. You hear the word popcorn, you give a statement to police after that, right?
Okay.
Right?
It didn't, whatever was said, it didn't change my views, because I heard and I saw what I experienced.
You gave a statement after that, that's the question.
Yes.
And then, when you're walking out of the theater, you and Miss Monero, one of the detectives introduces you to Sheriff Naco, right?
Okay, I believe so.
Okay. Well, you remember that.
I remember meeting police officers. I don't know, I can't recall what Sheriff Naka looks like.
You remember shaking his hand and introducing himself?
I've met several police officers that day. I really don't recall.
Okay, so you don't recall whether is what you're telling us, you don't?
Yes, I spoke with several police, law enforcement. I can't recall who I saw and spoke with.
All right, do you recall this then? Sometime after that, you get a communication from the sheriff's office. They want you to come to receive a plaque for heroism.
Okay, I remember that.
Do you remember that?
Yes.
And you received the plaque, right?
Okay,
Well, did you receive the plaque?
I did.
And the plaque says something to the effect of, for your brave, quick thinking in aid of another person in the event of a life-threatening situation, right?
I believe that's what the plaque says.
And I imagine when you made the acceptance speech, you said, I don't deserve this. There was somebody there before me. Did you tell them that?
I don't recall saying that there was someone there before me. I was just saying that I was just doing my job.
Did you tell anybody that there was somebody there before you helping this man?
I can't recall that.
And so now you receive a plaque from the sheriff's office. So really you're kind of beholding to the sheriff's office and state attorney's office, aren't you?
Can you rephrase that, please?
Do you not understand the question?
No, I'm just trying to say what you're trying to get at.
I don't have any other questions, Judge.
Thank you. Redirect.
Yes. When Mr. Oulson fell to the ground, or let me rephrase that, where were you working on Mr. Oulson?
So when I initially went over to Mr. Oulson, I was at his head side. Sorry, I was at the top near his head.
Okay, and where was that located? Where was Mr. Oulson's head?
Mr. Oulson, if the aisle, if the stairway is to the right, his head was towards the middle, like pointed towards the middle part of the aisle.
Was he on the ground?
He was on the ground,
Completely on the ground?
completely on the ground.
Because during cross, you mentioned that it was dim. Was that because he was on the ground?
I just think it was just the lighting conditions.
Because he was on the ground?
He was on the ground, yes. Because at that time, I don't think the full house lights were up yet.
I think you answered this on cross, but when you made the statement, either before or simultaneously with the shot about throwing popcorn on the face, are you, because I think this might have been the question on cross, are you making that up because you received the plaque for helping save Chad Oulson's life?
Objection,
No.
that's improper.
Well, that was what the implied.
Overall.
Were you making up about the popcorn
I did not
because
make
you
that
saved
up.
Chad Oulson's life?
I did not make that up.
Or trying to?
I heard those exact words, throw popcorn at me.
Okay, and then you were asked whether or not you were aware that someone else was doing CPR. Do you remember that question?
Yes, because I remember when I was on call with 911, someone was doing, asked someone to do chest compressions.
Okay, but here's what I'm asking you. Was it important to you to look around and see how many people are helping you and maybe get their name? Or was it more important to help save Chad Oulson's life?
It was more important to save Chad Oulson's life.
I don't have any further questions.
Thank you. May this witness be released?
I'll be keeping my standby.
Okay. Mr. Friedhoff, you're free to go, but if you get a call and they want you back, you'll have to come back, okay?
Okay, thank you.
Thank you.
Thank you.
Stay.
I just want to.
You may. We'll be taking a break before we get into anything lengthy, so don't worry.
I don't know if you know it, but Hernando County Courthouse is under a month right now.
All right, at this time, stay with us.
All right, thank you, Mr. Rosenwasser. Ladies and actually, okay. I was going to let you go take a recess, but I think we'll, the attorneys and myself will have some work to do following the rest by the state, so good time to let you go, correct, for the day? That's what we talked about? Okay. All right, so I know it's early for you guys, but it really is the best use of your time to just let you go on your own time, because the lawyer, like I said, the lawyers and myself have some stuff that it's going to take a while that we have to talk about, and no sense having you hang around for that. So let's be back at 8:30 tomorrow morning. Tomorrow is Friday? Whew. All right. Just be back at 8:30. Remember my instructions during the recess. And Thank you for your patience this week thus far, and we'll see you in the morning. Enjoy a little bit of afternoon off. Any questions? Okay, thank you. I think the weather's nice out there. You guys, I guess I keep forgetting, come a little early to do your stuff with the clerk. Thanks. Thank you, Deputy. All right, be seated.
So if we could maybe have 15 minutes ourselves
Sure,
to get our
it's-
arguments and everything, maybe 20 minutes to get our arguments in line.
That's fine. Come back at, say, 10 till? That'd be good, or?
That'd be perfect.
Okay. All right, we'll be in recess till 10 till. All right. State having rested, are there any motions?
Your Honor, we would make under Rule of Criminal Procedure 3.3 AO a motion for judgment of acquittal in this matter. If I may argue from the seated position.
You may.
It'll be a little easier for me.
Go ahead.
Your Honor, we've got a case of Morgan v. State, which cites many cases, for its proposition. It's a 5th District case. It's located at 127 Southern 3rd, 708. It's a 2013 case. And so this is why this case is unusual. To be honest with you, I was quite surprised that they were going to introduce Mr. Reeves' statement in this case, because normally, and I agree, this is what this case says. The question of whether a defendant acted in justifiable self-defense is generally a jury question. And that's normally because that first comes up when the defense does a presentation. What I was quite surprised that they did is that they put Mr. Reeves' statement in their case in chief. And that creates, I think, a problem for them. And this is why it creates a problem for them. That statement of Mr. Reeves has not been refuted by any single piece of evidence in this particular case, period. Let's look at what justifiable use of force is. Under the law, under both 776.012 and 776, as the court recalls, it refers us also to 776.013. And so I'm going to read those again because I think it's important for us to keep this in mind. A person is justified in the use of deadly force and does not have a duty to retreat if he or she reasonably believes that such force is necessary to prevent imminent death or great bodily harm to himself or to herself or another, or to prevent the imminent commission of a forcible felony. And so that's 776.012. As we know, there's a second section, which is B, which it says, under those circumstances also permitted under 776.013. So I'm going to read that. A person who is not engaged in an unlawful activity and who is attacked in any other place where he or she has the right to be, has no duty to retreat, and has the right to stand his or her ground to be forced with force, including deadly force, if he or she reasonably believes that it is necessary to do so to prevent death or great bodily harm to himself or herself or another, or to prevent the commission of a forcible felony. And we know that the law is clear that the danger does not have to be actual. So, let's make that abundantly clear. I don't think the prosecution is going to disagree with this. The danger that Mr. Reeves perceived does not have to be actual. The only thing it has to be is that Mr. Reeves reasonably believed that he was in imminent danger from that observation. That is it. And so when you take his particular statement, it was two statements as the court recalled. There was a first statement that was about 30 minutes. There was a second statement that was much shorter. He laid out the groundwork that this was a self-defense case and that he was scared, and the reason that he was scared and that why he had to use his pistol and the fact that the phone was thrown at him, and the fact that, those particular hands were coming in his direction. So let's talk about the phone, because clearly the phone is a deadly weapon. Hey, their lead detective testified. The phone can be a deadly weapon, hands can be a deadly weapon, and both of those can kill. There's absolutely no doubt that there is evidence here that a phone was in between Mr. Reeves' legs immediately after he fired the shot that resulted in the death of Chad Oulson. Immediately, because we know that Mr. Hamilton came quickly over to Mr. Reeves' side, looked down, and there it was. It has not been refuted. It has not been refuted in this particular case that Mr. Reeves says, I think that that phone hit me in the head. That is an aggravated battery under any circumstance. You don't have to have serious bodily injury. You don't have to have any of that if you're throwing a deadly weapon to an individual and it strikes that individual. So we've got clearly an aggravated battery that has not been refuted under any circumstances. We also have a regular battery. We have a felony battery on a person 65 years of age or older on two occasions. One occasion, obviously, is the throwing of the phone. The second occasion is when they grabbed the popcorn and threw that popcorn at Mr. Reeves. That's a felony battery. You know, to be honest with you, I'm sitting here and arguing this, but that's the law. I wish the law was a bit clearer, you know, in differentiating, you know, that particular, but it's a battery. If it's an unwanted touching, it's a battery. You know what else it is? And again, I almost feel a little silly arguing this, but it's a robbery. Because if you're threatening someone, and in the act of threatening someone, you grab that popcorn and you pull it and you throw it back at the individual's face, that is a robbery. Now, you don't even have to go there. You don't have to go to the robbery. In my opinion, you don't have to go anywhere because we have clearly a phone being thrown that Mr. Reeves says hit him in the head, and it's been not refuted. If the prosecution tries to argue that it was refuted because nobody saw it, that's not refuting it. That's not refuting that particular fact. So, you know, I think, Your Honor, and I'll be honest with you, I think the prosecution put themselves in a very bad position in placing that particular statement of Mr. Reeves, you know, in trial in their case in chief. Because otherwise, you know, we would be sitting here saying, okay, well, you know, what do we have at the end of the day? We have a bunch of their witnesses saying this happened. No witness talking about self-defense. This is very unusual, and we were, frankly, yesterday very, very pleased that they did what they did, because I think now it's clear, even in the light most favorable to the government, it is crystal clear that none of their evidence has refuted what Mr. Reeves said in that tape statement. So I would ask the court to grant us our judgment of acquittal. And by the way, on Nicole Oulson, whatever intent Mr. Reeves had in defending himself against Chad Oulson transfers to Nicole Oulson. So he can't be, at this point in time, guilty of the aggravated battery of Nicole Oulson either. And so it hasn't been refuted, Your Honor. I know that it's a tough decision for the court to make any time that the court is rendering a decision on a judgment of acquittal. But this record is crystal clear.
Thank you.
I have to agree with Mr. Escobar that this record is crystal clear. Unfortunately, I have to say it's crystal clear in the opposite direction. In taking the evidence in the light most favorable to the state, which of course is the burden at a judgment of acquittal argument, the state has put forth sufficient evidence to go forward to the jury on murder in the second degree as well as aggravated battery. I think Mr. Martin's going to handle the aggravated battery. It's kind of tied in just a tad with murder in the second degree. All the elements of murder in the second degree have in fact been proven. We have that Chad Oulson was dead. It was done by the criminal act of the defendant, and it was done through an act that was imminently dangerous to another, evidencing a depraved mind with ill will, hatred, spite, or evil intent. I have some case law if the court wants to read it, just about those other elements, but I don't think based on the arguments it's necessary. Really what the defense is indicating is that the state has to somehow rebut the defendant's allegation of self-defense, and because every single eyewitness indicated it didn't happen, somehow we have to accept the defendant's word. And I'm having a hard time wrapping my head around that. The evidence in this case is that every single witness that we called said the defendant's version of events simply didn't happen. There's a video and evidence that the court has reviewed and has seen in the past, and it's been played again during this trial, that absolutely with 100% certainty contradicts the defendant's story. There's a case that I can cite, and I can also present a copy to the court. It's Leisure. And I will, may I approach?
Yes.
It's a copy for defense counsel. It's Leisure, 105 Southern 3rd 5. It's a second DCA of 2012. And basically what this case states is that the jury can outright reject any claim by a defendant. And we've put forth sufficient evidence, especially at this juncture, just that we're arguing about a judgment of acquittal, to rebut the defendant's allegations. There's some, I guess the defendant according to the defense's argument, was definitively struck by a cell phone. The court would recall there has been no testimony or evidence of that whatsoever. In fact, the defendant himself doesn't know if he was hit by a phone. He says it might be possible, and the reason I think it might be possible is because, well, something happened, and I looked down at my feet, and there's a cell phone. I'm putting two to two together. I guess it was a cell phone. Looking at it logically, and there's no secret in this case about this, had the defendant been struck with a cell phone, I think it'd be reasonable, and especially for an argument of JOA, that there would be some form of injury. Now, this some form of injury certainly isn't this left corner of the eye or eyelid injury, especially if it's being used as a deadly weapon. The definition of a deadly weapon is as follows, I'm sure the court knows this. A weapon is considered a deadly weapon if it's used in a way, I'm going to try to slow down. I get going, I get fast. If it's used in a way likely to cause death or great bodily harm. So a cell phone, in and of itself, is not a deadly weapon. It's the manner in which it was used. If he were to toss a cell phone, that wouldn't be an aggravated battery. That would be a battery because it touched or struck him against his will. Because he was over 65, it would be a felony battery, which is going to be my other argument. So if the court needs a copy, I can give the court a copy. I'm sure the court's aware of this. There's different standards within the self-defense instruction. There is an applicable forcible felony section, but there's just another section that only talks about the generic felony. Okay? In that section that talks about just the generic felony, I'm going to read it because I don't want to misquote it. It says, the use of deadly force is justifiable if the defendant reasonably believed. Let me stop there just for the JOA argument. There is no evidence at all that would support the defendant's contention that he reasonably believed at the time of the shooting he was going to die. I mean, that's basically what the instruction states, imminent death. So there is absolutely no evidence that at the time he fired that shot, he could reasonably believe he was about to die or suffer great bodily harm. At the time the shot's fired, there is no way in the world, based on the evidence presented through the witnesses in the video, he reasonably believes he was about to suffer great bodily harm. That's what the instruction states. So the use of deadly force is justifiable if the defendant reasonably believed. I submit all the evidence so far shows he certainly did not reasonably believe it. But anyway, going on, believed the force was necessary to prevent imminent death or great bodily harm while resisting. He's not resisting anything. And then it talks about an attempt to commit a felony upon him. So let's say the felony that's being suggested, which was what Mr. Escobar was arguing, is battery on someone over 65. It was over. He's not resisting anything. What happened was, as popcorn was tossed on him, that was done. Mr. Oulson's hand was coming back. The act was complete. There's nothing he's resisting. It was done. And he decided, based on the evidence, that he was going to shoot and kill him at that point. So he wasn't resisting anything at that point. The robbery conversation, or I guess argument that Mr. Escobar made, the defendant himself states in his own taped statement, when Mr. Oulson jumped up, the popcorn went by the wayside immediately. I don't know if it fell out of my hand or if he knocked it down. I don't know. There is no robbery. There was no force, violence, assault, security, and fear that he was aware of. So that certainly wouldn't apply. And that's going to end up being my argument later on when we get to jury instructions. In the case that I presented to the court, it states, and I already alluded to it, and this case is even better for us than the argument I'm advancing, because in that case, the Leisure case, it states, even when there are no other witnesses to the event beside the defendant, because a lot of times there's a homicide and the only witness is the person who has passed away, a jury is not required to accept the defendant's testimony to support his or her self-defense theory as true. It must consider the probability or improbability of the defendant's credibility in light of the circumstances established by other evidence. Leisure's numerous inconsistent statements cast significant doubt on her assertions. And that's exactly what we have here, except for the fact that we have multiple witnesses who are saying what the defendant's stating took place didn't happen. And even if you discount all of those witnesses, the video indicates that it never happened. So there is no justifiable use of deadly force here, because at the time of the applicable battery, He wasn't resisting anything. But even if that argument was to be made, he could not, based on the facts and circumstances introduced in the evidence so far, reasonably believe that killing Mr. Oulson was necessary to prevent his own death or great bodily harm occurring to himself. The facts, just real briefly, for just other elements, is that there has been a period of time within which that the defendant could develop animosity towards Mr. Oulson. It was about 4 minutes between the initial encounter and the time of the shooting. And again, there's absolutely no evidence whatsoever that this was a lawful use of deadly force, and therefore I would argue that the defendant's motion for judgment of acquittal should absolutely be denied.
Judge, if I may just have a couple of points here. Again, I think that, their problem, they're talking about this video. This video supports us. It doesn't support them. If you look at the video, you'll see that about 8 to 10 seconds before the actual grabbing of the popcorn and throwing it back, you actually see Mr. Oulson actually coming over the seat with a hand. It is at that time that Mr. Reeves, in his statement, is saying, hey, listen, I see him coming over. You can see it on the video. Take a look at it if you like. We've got it in circles, that our expert has actually circled that particular area. It was at that point in time that Mr. Reeves says, hey, listen, I believe that he hit me either with a phone or with a fist or something, but it hit me on my face. It knocked my glasses askew, and I was a little bit dazed at that point in time. That is an aggravated battery that has not been refuted. Guess what? There's not a single witness that they presented in this trial that refutes that. But then there's a second. Then what happens is about 8 to 10 seconds thereafter is when the hands start coming through. And I want you to look at the fractions of a second that it takes for the shot to take place. It's fractions of a second. It is an absolute impossibility for Mr. Reeves to have shot Mr. Oulson because of popcorn. It's a human impossibility. But it doesn't matter because of the fact that nobody has refuted what Mr. Reeves said in that tape. Frankly, when we went home last night, we were shocked that they had put those audios in because they were good for us. We were going to sit here on a judgment of acquittal and say, okay, well, Judge, we have a judgment of acquittal, and that's my argument. But when they put that in, I thought that they had made a huge mistake, and they have. Think of the witnesses that were presented before this court. Nicole Oulson didn't see anything, okay? Nothing whatsoever. Mr. Cummings doesn't refute what Mr. Reeves says in his statement. Certainly Mr. Hamilton doesn't because he's only seeing silhouettes, okay? And certainly the lead detective doesn't. There is not a single witness that they've presented that refutes Mr. Reeves' statement in that oral tape, in that recorded tape. Nothing. And so what does that do? If you look at the Leisure case that they're talking about, I think Leisure, that motion of a judgment of acquittal that they're talking about happened at the end of both the state and the defense case. We're talking, and the case that I'm citing here, and we'll give a copy, let me have a copy to the court. Some of the language is not good because normally in situations like this, may I approach?
You may.
More. And can you give one to the same? Normally, Your Honor, in these situations, if you look at Morgan starting on page 8, I'm going to read what the court says. The question of whether the defendant acted in justifiable self-defense is generally a question for the jury. I agree with that. It's a Supreme Court case that they're citing, Rimmel versus State, located at 532 Southern 2nd, 16. However, look what it says at the very bottom. However, a motion for judgment of acquittal based upon self-defense should not be granted unless the evidence is such that no view which the jury may lawfully take of it favorable to the opposing party can be sustained under the law. And the law, again, is the danger doesn't have to be real. It only has to be reasonably perceived by Mr. Reeves. They have not one scintilla of testimony that refutes his version on that. And so they're stuck with that particular tape. They put it on. They didn't put anything on to specifically refute his perception And therefore, the court has to take that perception what it is, because it hasn't been refuted. And this jury can't do anything with it because there's no evidence to contradict it. So I would ask the court, again, to look at 776.012, 776.013, and understand this. The law does not punish one that reasonably believes that they need to use that force to protect themselves against great bodily harm or death. They don't have to be right. They just have to reasonably believe. There's a big difference. That's the beauty of this law, because you can make a mistake in that whole process, and the law still's not going to punish you as long as you reasonably believed at that time. And we've got Mr. Reeves talking about his law enforcement career, talking about what he has done in that particular area that, again, was never refuted. And they didn't bring in any police officers to say, hey, Mr. Reeves wasn't a very good police officer. He didn't know anything about use of force. He was not commander of the SWAT team. He didn't know it. Just the opposite. They were silent on that. And so, Your Honor, respectfully, we're looking at every single witness here. They haven't refuted this, and they're stuck with that recording.
Thank you. All right, as far as the statement played of the interview of Mr. Reeves, I found that there was a great deal of evidence that refuted some of his statements. For instance, the whoa, 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 ho, no, no, no. Pretty much every witness that claims to have heard or seen something said they didn't hear that. And I know you've said several times now since the beginning of the trial about the 10 seconds prior in the video. It's clear to see that the defendant came over the decedent came over the chair and, was taking a swing or something at Mr. Reeves. I didn't see that. I looked hard as I could look, and I did not see that in the evidence that's before me at this point of the trial. So I think that evidence refutes the claim that there was the first attack, that it's been called, and the lack of any marks, that somewhat, but I agree with defense, that wouldn't be enough on its own to refute that. But even in Mr. Reeves' own statement, he says in the second part that he's not sure. He's not sure if he got hit. He's second guessing himself. And I think with all of the evidence that's been presented, the state has overcome the motion for judgment of acquittal. I'll deny. All right, what else do we need to talk about today?
Judge, the only judgment of acquittal I heard was for second-degree murder, so.
Oh, sorry. Yeah.
We argued for both.
Yeah, and this thing, you correctly identified the fact that with transferred intent, if you prevailed on the judgment of acquittal as to the second-degree murder, I think that would apply to the aggravated battery, and you probably disagree, but
No.
okay.
It don't.
Right, okay. I don't. I think, okay.
agree on.
Okay.
All right, do you need any further arguments then on count?
No. I'll deny the motion in its entirety as to both counts. All right, do we have any other smaller motions that are still outstanding?
We're going to try to make them smaller later.
Okay, the main ones regarding the experts.
Yeah,
Okay, I thought that was all we really had outstanding.
yes. We'll do the heavy lifting.
Okay.
Outside the courtroom and see if we can narrow it down for the purpose.
All right. There's a lot of case law, on these issues, so hopefully you can do that.
Well, it's not going to be much more than that 100-page doubter motion I filed in the quality case law. So if you read that, you know what the case law is as far as the state's concerned. So that's what the state will be relying on.
Okay.
And Judge, I think we've got, 5 witnesses who will be here tomorrow.
Okay.
So I think that should hopefully, Smith is going to be long.
Yeah,
You
I
know, and so
figured.
I'm thinking 5 to do our presentation.
Okay.
We'll see if maybe there's, we'll get you a list, absolutely. We will see if maybe we can even squeeze in a 6th if we find someone that's available.
Okay.
We normally, we're supposed to give them like a day ahead notice.
Right.
So
They
we-
appreciate that.
We've got 5, for sure.
If they're local and, retired or can get off work or whatever, but
There seems to be a lot of retired people in this class.
fortunately so. All right, so how are we looking then for time realistically?
I think it's going to take us next week.
Do you think you can be done by Thursday?
We will try our best. I can tell you more tomorrow, we'll talk about it.
Okay.
We'll
Yeah,
what
see
the
how
lineup is
tomorrow
gonna be
goes,
for,
yeah.
For Monday and Tuesday.
Mm-hmm.
And see if we can get our list of witnesses. I'd like to try to, put as many witnesses, quickly. The problem that we have is, we have Dr. Foley, who is a practicing radiologist, so we're gonna have to fit him in somewhere. And we've got our Jacksonville, expert that,
Is that
coming from
Dr.
Jacksonville.
Cohen
That's a Knox.
or Knox? Okay.
And there's still an
Coding is
issue,
easy.
there's still an issue with Mr. Knox because of those, my doubter motions haven't occurred on him.
Okay.
So, and
Right.
it was to be during trial, so.
Right, I know. So, yeah, that's,
The transcripts, you got the transcripts.
I do.
Right, and you have, I think both sides have thoroughly briefed the issues.
Yes, you have.
So.
Yeah, so
If
hopefully,
the court has read and absorbed that, then the court's decision
yeah,
with the testimony should.
hopefully we can get that with minimal delay. But yeah, that certainly will help, the fact that you've briefed thoroughly and I've read the transcripts, so,
Because my argument's not going to be any more than what's in there.
okay. All right. We'll keep our fingers crossed. All right, well, I guess we'll have an early day today then. I'm sure none of us mind that.
We welcome it.
I'm telling you, and I just want to take the opportunity, thank you all. So far, so good. Everybody's been doing a great job. It's a tiresome job on you guys' part, but you've all done really well, so I appreciate that. Thanks. All right, we'll see you at 8:30 in the morning then. Thanks, everybody.